follows. The appeal is dismissed with costs, including the cost of 2 cancer person or head classes.
In the matter between the President of the Republic of South Africa and another, and Prince Bonisika, kaZwelithini and others.
My Lord, President and members of the court, we have a short application to bring to the effect that Prince Simagade was actually a party in 2 matters before Justice Madondo. I've spoken to the learned friend for Prince Mbonisi. He has no objection to us bring this application. I have also spoken to my learned colleague, Mr. Dodson. I suppose he can place his attitude on record before I do what I intend to.
Oh, so Mr. Morani, if I may ask, what's the purpose of the application? Is to show what?
Just to show that, in fact, contrary to what has been assumed, and that Prince Simagade was not a party to 2 of the applications before Justice Madondo, that the truth of the matter is that, in fact, he was a party. That is the sole purpose of that. Yes, we don't intend arguing any further, just placing that factual situation before the court.
All right.
Yeah.
Mr. Masugu, sorry, Mr. Ngwaitobi. Sorry, Mr. Ngwaitobi, what's your attitude?
Thank you, Justice Sondi. We support the application. We've had to scramble yesterday from the heads of Mr. Madonsela, my predecessor in the Pietermaritzburg High Court, to show that Prince Magade was a respondent. But there is actually a simpler solution, which is what Mr. Moran is raising.
Thank you. Mr. Masugu?
We have no objection.
Yes, Mr. Dodson.
Thank you, Deputy President. We received these at 8:30 this morning.
Yes.
As I will make clear in my address later, we had similar conduct in the hearing in the High Court. When all the pleadings had closed, suddenly there were, I think, something of the order of 800 pages or more that was bombed into the proceedings from various other court cases. And in fact, it's the origin of the problems with the record is precisely this type of conduct. We don't accept that the documents that are put forward do indicate that Prince Magade was a party to the EC application. All it is an Annex A that includes his name and many other royal family names, along with those that Judge Madondo himself recognized as not having been joined. There's no indication that it was served. But what I propose as a way of going forward is our objection should be noted in the same way that we've objected to the other avalanche of documentation that was infamously filed, and I'll clarify the circumstances that we can't now give my address. But we're not going to stop the court from looking at it. And we don't dispute that Prince Makade's name, along with I think 29 or more others from the royal family, are there. It certainly doesn't indicate that he served the application, but as long as the court understands that by our allowing it in, our objection stands along with all the other documentation. I think it's also correct to say that the notice of motion and Annex A were in fact part of the record in the High Court and were omitted in this record. were part of our objection. But we're ready to deal with it. We're ready to deal with it as if it was part of the record, but we don't accept it.
All right, let me see if I understand your objection, the nature of the objection, Mr. Carson. Do you object to the handing up of the document on the basis of the procedure or on the basis of what it purports to achieve? What is the nature of the objection?
The nature of the objection is it's late arrival. It's late arrival both in the High Court proceedings and it's late arrival in these proceedings. But we don't have any difficulty with the court looking at it as long as our objection is noted and we're ready to deal with it.
All right, Mr. Moran.
Yes. Yes, please. May it please the Court, what these documents show, starting with the case of the princesses, Princess Ntandwe Zulu, case number 2752, what it does show is that the sixth respondent was a composite number of respondents. In other words, the members of the royal family listed in Annexure A, and in Annexure A, the name of Prince Simagade appears under Gwakangela Mankengan Royal Palace, and his name is the 27th. The 27th in the list, on page 10.
It's 26. Number 26.
No, Prince Ntandwe Nkosi. There are two applications. There's,
Okay, all right.
yes, this is the one of the princesses, the one that came first.
Yeah. 2752, I see.
Yes, he's the 27th member of the royal family appearing in Annexure A.
Oh, yeah, I see. Okay.
Yes. And in the other matter, matter of Prince Mbonisi, it is case 10879. He is under the composite eighth respondent, members of the Zulu royal family as listed in Annexure A, to notice of motion. And is the 26th member of the royal family in this one.
Do we know if these papers were served on all those listed in annexes?
Well, I cannot say as I'm standing here whether. All I know is that in one of the matters, as we've already heard, Prince Simagade signed a confirmatory affidavit, and he must have been aware of these proceedings, and he must have been aware of the proceedings brought by the princesses, and he must have been aware of the proceedings brought by his brother, his uncle, I beg your pardon, Prince Misuzulu. In any case, he's cited as a party. Apparently this matter was on television yesterday, and one of the people who was involved in the matter originally saw it and brought this to our attention.
All right. Maybe just to address the point that has been raised by my sister, Nichols. Can you file sort of an affidavit to tell us what had happened? He was number so and so in matter number so and so. Documents were served. He's aware, because at this stage, it's not clear to us whether he was aware of the proceedings, whether the notice of motion was served on him.
Yes.
So I think that will assist us.
Yes.
Unless if there is anything further that you want to say?
No. That's all.
Anything? Okay, thank you. Thank you, Mr. Moran. Mr. Misuzulu.
President, and Justice of the Court.
Also, it's not in connection with this.
Oh, yes, no, we would ask that the directive by the court also includes
can I then, because there was an objection from Mr. But let me start with Mr. Nguwaitobi first. We have heard what Mr. Moran has said, and we have heard what the directive that we have given.
We will abide.
Yes.
We might put in our affidavit, but at this point, I just want to reserve our position, but we shall abide.
Right, by when are you going to, because we can't, I think that there must be a time within which to file the necessary affidavit.
Could we have at least a day? Tomorrow is Friday.
Yes, for Monday, Mr. Moran.
As it is.
Okay, Mr. Dodson.
Struggling a little bit here for the back here, Deputy President, but as I understand it, you indicated to my own President Ryan that they will be required to file a formal affidavit
Yes.
to introduce the documents, and I think we would like to be able
Yes.
to file an answer for that.
Right. I think that's the best way to deal with this, with the filing of further documentation, because there must be an affidavit, and to explain whatever you need to explain by way of an affidavit, not from the bench, from the bar, sorry. Okay, so it will be done by Monday, and you'll be entitled to respond. So. Monday, they are going to file And please, can you reply by Tuesday? Okay. So whoever wishes to file an answering affidavit or to Mr. Morane's affidavit can also do so by, say, Tuesday. And I'm not sure if Mr. Morane will need to file a reply. I don't think so, but it's entirely upon it. But if you are minded to file a reply, you can do so by Wednesday.
As the court says, it really depends on what is said.
Yes.
It might not be necessary. Thank you.
Okay, I think that we are done now with the interlocutory application. Mr. Masugu, I just want to remind you that your 2 hours time that had been allocated to you was almost over. We started with you at 14:20 and we adjourned the proceedings yesterday at 16:15.
Was it 14:20?
Sorry?
Was it
14:20?
I thought it was
14:20 you started.
I thought it was 14:30.
14:20 you started, Mr. Masugu.
If the court would allow some latitude, there is an issue raised by you, President, which I would like my learned friend Mr. Smelane to deal with in 10 minutes, relating to the question you asked about the custom that the royal family does when they sit in the palace and they decide on who should be the heir, what exactly they do. I requested him to look at that and to give a rebuttal on it. But I will crave the court's patience for me to try and close down my argument in the next 15 minutes, so that he has. I beg your pardon.
How much time do you need now?
For my part of the argument to close down, I would like 15 minutes, and perhaps 15 minutes for him, so that we have 30 minutes here.
I think that we need to be fair to everybody.
If
give you extra 3 minutes, then I think that we need to give others.
It's fine. We would have no objection to
Let's see
that.
how it goes.
Yes. Thank you.
Yes, Mr. Masugu, you may proceed.
In fact, yesterday I ended up with pointing out that the issue of res judicata falls away because even Justice Madondo himself, in his judgment, anticipated that he did not close the door to any member of the royal family wishing to review and set aside the identification or the recognition decision. So res judicata in the High Court was applied in an oppressive manner, and the exercise of discretion by the Kotako did not accord with the rights of the royal family. And we would say that the law in that regard would be that when a court exercises its discretion on the principle of res judicata, it does so with due regard to the rights that are engaged in the matter. This matter is of such complexity that to decide the issues that it decided, which were not in fact in the main issues that the case was about, was to apply the res judicata principle in an oppressive manner. We say in an oppressive manner because it denies the Zulu royal family its constitutional rights to sit as a family and to consult with each other and to decide on who should be an heir. And then I wanted to also refer to the judgment of Justice Madondo in paragraph which President referred to yesterday, paragraph 102. In paragraph 102, which also essentially reserved the rights of the royal family to challenge the decision of the referral decision. Let me just close down this. So we would say that the way to deal with the res judicata point was to look at whether the res judicata point would cause undue hardship to the family. And right now, with this dispute having escalated as it has, it seems to us that there is a considerable hardship that the application of this res judicata principle has had on the royal family. And then may I then finally deal with the issue relating, then let me make the final submissions in relation to the President's decision, which is the following.
Recognition decision.
Sorry?
Recognition.
The recognition decision, yes. The jurisdictional requirement for a valid recognition decision is a valid identification decision. In other words, a lawful identification decision is a requirement for a lawful exercise of a recognition decision. And we have submitted that the President did not have a lawful identification before him. He also did not have an application by the royal family that could have justified him exercising the powers that he did in recognizing the King Misuzulu. And then there was an argument yesterday made that the meaning of Section 8.4, in particular, the reference to evidence or allegation requires more than just evidence and allegation for the President to refer the matter to an investigative committee. Well, no, it can never be suggested that there was no evidence that the recognition decision had not been done in accordance with the customs and the customary law and the Zulu customary law. It can never be suggested because.
But at this stage, Mr. Masuku, is it evidence or allegation?
No. I want to suggest that it is evidence. The evidence that was there, or that there was a dispute, or that the identification process was not in accordance with the Zulu the customs, were the minutes of the meeting of the 14th of May. And I pointed out yesterday in those minutes that if the President considered those minutes, the question he would have asked himself is, are these members of the royal family? Because that is the primary question he must ask himself. Are these the members of the royal family with a right to identify an heir? And that's evidence before the President. And bearing in mind that when the President received these complaints, or the referrals to him by Princess Tembi Ndlovu kaZulu and Prince Mbonisi, when he received the letters, he did not consider those letters to be frivolous letters. He didn't. What the President did was he looked at them and he said to the Minister, Minister, can you help and advise me on this? On his own, and you will see that the Minister did not consider those disputes that had been raised as frivolous disputes. In fact, what she did was to appoint an ad hoc mediation panel, to investigate those, to try and mediate between the members of the different royal family members on the issue of the...
Well, the issue, Mr. Masuku, is whether in those letters a custom was identified which had been breached. I think that's
yes. No. We've submitted that. Yes. If one looks at Princess Tembi's referral,
yes.
There was a
lack of the
good,
3rd of June.
Yes, there was a good amount of references made to why the identification as having been announced was wrong.
Okay.
And if you look at the letter read by my learned friend, the letter on behalf of Prince Mbonisi, which was from his attorneys, Mabaso, it raised precisely the fact that there was a dispute, particularly on the issue relating to whether the royal family was involved in this identification process. And here, bear in mind, Honorable Justices, that what's being the alleger of this dispute brothers to the late king. These are not people coming from somewhere. These are direct descendants of, they are directly related to the late king. And when they say that their role was subverted, that can't just be a frivolous allegation. That does not trigger an 8-4 response. And so, I would say, so the evidence I've suggested is the minutes of the meeting.
Well, but the problem with that proposition, Mr. Masolo, is that some were invited to the meeting and they declined. So
No, but as I pointed out yesterday, President, when the meeting of the 14th set,
yes.
It was a meeting firstly of the royal family which was performing a morning ritual. That was the first issue. And when Prince Buthelezi realized that that meeting would have a number of attendees from the royal family, he decided to piggyback on that meeting, the identification meeting. So, to say that Prince Mbonisi and Princess Thembi were invited and they declined to come, what about the others who were there? There are 5 of them that we say are the core family members, core royal members of the ruling family. What about them?
Did they attend the cleansing ceremony? Were they there?
The Prince Mbonisi.
Did they attend? Were they in attendance of the cleansing ceremony? You said that they were there for the purpose of mourning. Or
no, they did not attend the cleansing ceremony.
They were not there.
They were not there.
Okay.
Remember, the meeting of the
14th
identification was in the afternoon. In fact, later in the afternoon, when the cleansing ceremony had been done.
Well, according to the minute, it's 1 o'clock.
Yes, but if one reads the record,
yes,
you will see that Prince Buthelezi himself says it was after the cleansing ceremony that the meeting was called. So, President, I'm concerned about my own time, so I'm wondering if you are going to be generous with my time.
No, I'm not going to be generous with you, Mr. Masolo. I've been generous enough.
Yes, no, because
so really.
I'll beg your indulgence to give me time.
Okay. How many points do you still
So the point I want to make is that even if you set aside the judgment of a call,
yes,
we submit that the finding that there were disputes, or rather that there was evidence or allegations that the identification of a person as a king was not done in accordance with customary law, was correct. That finding was correct. And you will see, as I submit, the president does not regard these disputes that are raised with him as frivolous. Neither does the minister who is asked to look at them, does she regard them as frivolous. In fact, she sets up a committee that deals with them. And I would invite the court to look at the report of the panel. In that report, you would have seen that it chronicles and records the different views of members of the royal family about why the identification was incorrect. The panel report itself. So we submit that it can never be suggested that the issues raised, which were before the president, because most of these matters come from the Rule 53 record, were matters that could be dismissed as frivolous or do not fit within the 8-4 duties of the president. In fact, if the president had activated 8-4, the issue of who the royal family members are, who should have identified, could have been resolved through that process of the 8-4 investigative committee. Instead, what we have is an ad hoc panel report, which obviously does not have any legislative foundation, but we accept that the president, if he had invoked a 8-4 and conducted an investigation, this issue of who is exactly is complaining and why are they complaining would have been resolved. Then we would not have been here if that power had been exercised by the president. So we would submit that the finding by the High Court on whether the president failed to exercise his 8-4 powers was correct, because there was evidence and there were allegations that the identification had not been done in accordance with the customary law. President, unless there are any questions, I would like Mrs. Melana to deal with the issue that was of concern to you yesterday.
Okay, thank you, Mr. Masood. Mr. Similane. All right.
Thank you, President.
So, Mr. Smilane, you have got only 5 minutes. It's 25 past now, so half past you should be done.
So what I'll do, I'll take you to certain references which the court can read in its own time. You raised the issue of custom because it was central yesterday in the various presentations. When you said the royal family is an institution, the Zulu royal family is an institution, I thought it should be of assistance if we remind ourselves on the definition of what the royal family is. It is an institution and it consists of immediate relatives of the ruling family. So what that tells you immediately from the definition is that it's the immediate relatives and it is the ruling family. So there is a ruling family within the Zulu royal family. The current ruling family...
Section 1 doesn't end there. If you go to Section 1...
Yes.
Yes.
Yes, for purposes of identification, the ruling family that meets is the one that determines the predecessor. And when I take the court where that comes from, in volume 3 at page 461, at page 461 we describe paragraph 48. It goes through, Deputy President, to paragraph 62, where there is a detailed description of what constitutes the Zulu royal family. Within that description of the Zulu royal family is the ruling family. So what we tell you there is that the institution of the Zulu royal family consists of 13 houses, royal houses. There's 13 royal houses. There's 12 that are mentioned there. Then there's the 13th where the king, the late king, was coming from. So there's 13 royal houses, and each one of those royal houses has its own head. Amakhanda is in Zobukhosi BakwaZulu. Ubukhosi BakwaZulu consists of those and nothing else, and everything else is below that. So we detail there. And Isilo, the late king, was Inkosi Yamakhosi, as in King of Kings, because he himself, in his own right, uInkosi. So because there's 13 of them, to distinguish him as Isilo, he had to be above the other kings. So he was Inkosi Yamakhosi on that basis. But it's still on the basis of the 13 royal houses. We go on there. So that's what constitutes the Zulu kingdom and the nation. Then we describe how they operate. So that's the organogram, that's the structure, and that's how the Zulu royal family operates. Then within those 13 royal houses, the ruling family in Lukapusha, which is the late king's father, King Misuzulu. That is the ruling family. From the lineage, in determining lineage of the kings, the ruling family in Lukapusha, which is the late king's father. And Amakhanda is in all those heads of those royal houses. It's not in dispute, determined that the next heir would come from Indlu Kapusha, which is the late king's father's house, royal house. Then in volume 5, at page 873, is a statement. It's actually an affidavit of one of the heads of the royal houses. Umntwana omkhulu uMaZulu, kaZulu. 872, volume 5. There's a statement there. What it does there, because Indlu Yakwaminyamazi is one of the 12, is one of the 13 that are there, and he's the head. He describes in great detail the architecture of the broader Zulu royal family, as I've indicated. And at paragraph 6 of his letter, of his affidavit, he talks about the structure and the important rituals that are carried out by the Zulu royal family as a whole. All those rituals that are listed in paragraph 6. At paragraph 9, he tells us, he says, the royal family always determines the royal house from which a king will emerge. So Amakanda, 13 of them, 12 of them, 13 of them determine where the next king, from which royal house the next king will come from. So he goes into great detail. Then at paragraph 13, he gives his view of the meeting of the 14th. Well, before paragraph 13 and paragraph 11, he expresses regrets at the role that the late Ushenge played in the ceremony, and you can read it, what his regret is there. And it's very simple. Undunankulu, the late Inkosi Ushenge, is from the Buthelezi clan. He's not Zulu. He's not Zulu. As a distant relative of the Zulu royal family.
But we have to accept that he was referred to as Prince Mangosuthu Buthelezi.
Yes,
for the reason.
He is a prince because he's a distant
so
relative.
you can't just wish him away. Can you wish him away?
No, Deputy President, nobody's wishing Ushenge away.
Yes.
I'm explaining his context, and we know how he's related. Umshana in the royal in Ndlu.
Yes. Yes.
In other words, he is a nephew to the royal family because it's through the late Princess Makoko, his mother, who was a princess.
Okay.
The organogram is important to understand it because that is custom. That is custom. It can't be wished away. It can't be changed, however anybody may feel about it. So what happens at the end of the day is that when a member, a senior member, a head of one of the royal houses expresses the regrets that he expresses at 11, that is significant because it is a head of another clan engaging in the manner that was engaged in the affairs of the Zulu royal family. So that's at paragraph 11. At paragraph 13, he gives his view of the meeting of the 14th, about what that meeting was about. Then at paragraph 14, he describes the rituals again that are performed. All of them. Those are all the rituals, and those rituals are mandatory. They are custom. They have to be carried out, including the cleansing of the cleansing ceremony. All of those have to be performed. Then at paragraph 15, he goes further. He describes the rituals that were performed by the Zulu royal family, but in which the late Prince Buthelezi was not present because they didn't concern him. Despite his role and his status, he can only go so far. For example, he wouldn't go that far. And that is known. So that is the custom.
Mr. I asked Mr. Masuko yesterday that if these rituals were not followed, did that invalidate the choice of the potential king or queen, because he seems to indicate it can also be a queen, and he said his answer was no, it wouldn't invalidate.
No, some of the rituals are rituals that are performed by the family as part of many events. For if there's a funeral, there's a cleansing ceremony, it has to happen. But here's what is important to your point, Justice Nichols, about whether it invalidates. It talks to the status of the meeting 14 and what it means. That was a cleansing ceremony. In Zulu custom, in Zulu culture, when there is a death as a custom mandatory, Zulu people observe the mourning period of Ubuzila for a certain period of time, during which period nothing gets done because Buziliwe. Nothing gets done. The normal day-to-day habits and activities that are performed are all put on hold. You don't even milk a cow during that period. The meeting of the 14th breached one of the most sacred customs of the Zulu nation, which is the mourning period. It took place, that meeting of the 14th was called not just on the day of the cleansing ceremony, it was called to discuss and nominate somebody as a successor during the mourning period. The custom was...
Sorry, Mr. Silane, I'm worried about time, but what about the meeting of the 5th of May? What about the meeting of the 5th of May in which Prince Monisi attended? Because if you say nothing should have been done during the morning period, then that would equally apply to the meeting that was held on the 5th of May.
For the point
you can't say to others, don't hold the meeting during the morning period, while at the same time you are holding meetings during the same period. It's double standard, Mr.
No, there's no double standards. For purposes of the point I'm making...
No.
Deputy President, can I make the point?
Yes.
The point is this.
Yes.
I've described, and the affidavit of Mtonumazo described the organogram, the culture, the 12 royal houses. Indlu Ebusayo, which is Indlu Gabusha, which is the late king's father's house, which is the ruling family. The definition of the Act says it is that family that sits and identifies. So in Indlu Gabusha, who do you have there? In the review application, we have 4 main elders there. Prince Mbonisi, Prince Vulindlela, Prince Mathule Sizwe, and Prince Umxolisi. And there's Princess Sulini. All 5, the siblings of the late king. So the siblings of Ubusha, the late Isilo Upeguzulu. Those are his children.
Sorry, did you include Princess Ndlovu? Did you include her?
Yes, Princess Ndlovu, yes. Okay. She's Ndlovu because she got married. Those, and Prince Umxolisi is here. He's the most senior person in this room. He's here in this room. He's the most senior person to all of them, including. Can I make a point?
Sorry. Mr. Smilan, I think that you are going to answer my question. My question was related to what happens during the morning period and whether meetings can be held during the morning period.
No, they can meet. The meeting, what the case is about.
Yes.
The meeting, the family that decides and identifies who the successor is, did not get an opportunity to do that because that meeting did not happen.
The meeting of the 5th of May.
No, I'm not talking about the meeting of the 5th. I'm getting to the meeting of the 5th. The complaint in the case, Deputy President, is that the people that are the ruling family in Lugabush that ought to have said, exercising their customary rights to identify the successor, did not have an opportunity to do that because of the events that took place before. The meeting of the 5th, the meeting of the 14th, those meetings are irrelevant for that point because that meeting did not take place. The other meetings did take place, yes. But those meetings, the meeting of the 14th, the minutes say so. It was a nomination and the name was given there and it was supported there. But the people in that meeting are not the Indlugabusha that decides who takes the throne to succeed the late king. It didn't happen. The elders...
So we must regard both the meeting of the 5th of May and the meeting of the 14th of May because they were during the morning period.
You don't disregard them. If you look at the algorithm and the statement of Prince Masu and Prince Mbonisi in his affidavit, they describe processes leading to identification. So custom, where you get to identify, follows certain procedures. It's not an event that it just happens like this. So there are meetings where the broader royal family meets and discusses. In fact, I want to say we put in
Mr. Smilane.
Yes, sir. Yes.
What is your submission? Is it your submission that the meeting that was properly constituted is the meeting of the 5th of May?
No, the meeting of the 5th of May was not properly constituted for purposes of identifying the successor.
But Prince Moniz was there, your client.
Prince, that was not a meeting to identify.
No, go to page 739 of the record. Go to 739 of the record.
We will go to that. What I'm describing, Deputy President, which you must understand, and you've got to understand this, to understand what all these meetings were about, leading to what the complaint is about. The broader Zulu royal family, as I've described, which is Amakanda, all 13 royal houses, have a role to play. They get consulted because of their lineage, which is undisputed. They've got to be consulted. Once there's a decision on the ruling house, which is in Lugapusha, the other royal houses, from principle of which you know, Okwebuza, they take a back seat. Okwebuza means that they take a back seat, and the ruling house takes charge, which is the house of the late King Misuzulu.
Yeah.
That's the ruling house in Lugapusha. And if Amakanda have decided that it is that house where the next king will come from, it is the members of that house only that decide who amongst the people there qualifies to be the king, and they identify that person. The other royal houses, from the principle of Uwebuza, take a back seat. They can't go and impose themselves there.
All right. So your short answer to my question is that meeting was unlawful.
It was not unlawful. It was not an identification meeting. It was a meeting of members. Call it a consultative meeting.
Do you want to read? It's written in isiZulu. The minutes are in isiZulu. 739 of the record.
Yes.
Okay. Just make
Yes,
things easier for you.
so I'll summarize it. I read it. It says, because of course, you see, that's what it should say. For that purpose, it is unlawful because it's not an identifying meeting.
Okay, you have answered.
But for purposes of contributing, Deputy President, to the identification meeting that was to take place, it's of value because it's consultative, because it indicates the views of other broader family members of the Zulu royal family. But the immediate relatives, who are then responsible for identifying, if they had had an opportunity to meet, as the custom dictates, they would have taken into account the fact that there are these other views. And when they consider all of them, they would take those different views as important factors in identifying which one specifically amongst them to identify. It just didn't get to that particular level because things took a particular event. So in essence, the meeting of the 14th of May, which the President regarded as the important meeting, my other friend, Mr. Masuku, dealt with it yesterday, its composition and where people came from that attended that meeting. That meeting was not an identification meeting. For purposes of what the case is about, the complaint is about that the applicants in the review application did not get a chance to meet and exercise their rights, exercise their custom to identify an heir. For that purpose, the meeting of the 14th does not assist this particular court and was unlawful for that purpose.
Well, I think that we've covered that point. Mr.
Yes, we covered that point.
It yesterday.
So, there's an issue about custom, the importance of custom and great wife. Just to remind the court that the funeral and all the ceremonies that related to the funeral of the late king took place at Waketontala in Paris. You know why? That is where the first wife resides, Queen Winifred Dlamini, the main wife. And everything took place there in recognition of the fact that she's the first wife and the most senior wife for that reason. It did not take place Wakangela, where Queen Mantombi resided. She was still alive when all of this happened. It didn't take place there. So the ruling family, in giving that clear distinction, without giving an indication who's great and who's not great, because there is no great wife. There is no great wife. The queens are in accordance with who came first in Lukul. Who came first in Lukul. So it took place, all the ceremonies took place at Waketontala, simply because that's where Queen Winifred resided. And there was no complaint from the late Queen, Her Majesty. There was no complaint, but she understood perfectly that ranking system. So when you look at the definition, who the immediate relatives of the ruling family is Kwapebuzu, late Pebuzu. That's the roof in Lugabush. That's in Lugabush. So the siblings, Prince Monisi describes it in his founding affidavit. His siblings, the late king's siblings that I've mentioned, Prince Mbonisi, Prince Vulindlela, Prince Matubesizo, Prince Mbonisi, those are the ones who sit and determine who the next heir is, taking into account all the other views. They didn't have an opportunity. As a family, remember, Deputy President, the late king, like a head of every household. The fact that his king is different, but first and foremost, he's the head of his own family. Himself, his wives, his children, like everybody else. And that is his family. So those customs that family has to perform, rituals, have to be observed just as much as the other extended customs of the whole Zulu nation. So the applicants and the case being made is that in our own family, Prince Mbonisi being the most elder, now that the king has since been deceased, could not lead that family in the manner that custom dictates, for the sole reason, and no other, for the sole reason that there were other participants who got themselves involved in those processes, and things turned out the way that they turned out. But by Zulu custom strictly, everybody should have observed the leadership in that house, in that family, in the same way that it happens in every other clan. So what the point and the order that they would seek is that the first order obviously be upheld, and that order 2 be dismissed because it stands on the first order and naturally the cost of 3 council deputy president.
Thank you.
And for that purpose, Deputy President, the point would be that what should happen then? The matter will be referred to the appropriate place, which is the Zulu royal family, to do what they ordinarily would have done, but what turned out to be.
Okay.
As the court pleases.
Thank you, Mr. Swela. Yes, Mr. Thompson.
Maybe ask if we can do a bit of musical chairs,
Yeah.
so that our team can sort of report and just go with this.
There's no one to tell them. Silencing Yes, Mr. Thompson.
Thank you, Deputy President.
Your 20 minutes starts now.
Deputy President, Justices of the Court, we've had the benefit over the last day and a half of listening to the exchanges that have taken place in the arguments presented. Like the proverbial curate's egg, they have been a good experience in part and a bad experience in part. Let me start with the bad part. It pertains to 5 documents that were relied on by my learned friend for Prince Misuzulu yesterday in his argument, all of which we say were inadmissible, prejudicial to Prince Simakade, and should never have formed part of the record. Difficult as it is to do, we would ask this court to think away all of these submissions that were made on the basis of those 5 documents. We applied in the High Court for the striking out of those documents, and unfortunately the application was never dealt with in Mr. Justice Davis's judgment, and hence their reliance by my little friend. In fairness to my little friend, I should say he wasn't part of the proceedings before the High Court, so he may not have been entirely aware of what had taken place there. But let me deal with the first one. That is the unsigned affidavit of the late Mr. Buthelezi. It is an unsigned typed document emerging from a law firm's typist. There is no affidavit by a typist or an attorney to suggest that it is a fair representation of the instructions that were given by Mr. Buthelezi. There is no evidence to suggest that Mr. Buthelezi approved of the draft. Prince Misuzulu patently cannot confirm Mr. Buthelezi's evidence. He is half of his age. He's never held the position of traditional prime minister. There's no evidence to suggest that he used to accompany Mr. Buthelezi, and there's no reason to suggest that he would have been at every meeting and so on that Mr. Buthelezi was at. So the confirmation, we say, is not worth the paper that it is written on. As we heard from my learned friend, for Mr. Mbonisi, the evidence on record is, in fact, that Mr. Buthelezi refused to sign that affidavit and remained so unwilling until his death because certain demands, unspecified demands, were not met. Even if it is accorded, even if it were to be accorded, contrary to my submissions, the status of hearsay evidence is only admissible in those circumstances if the person who actually gave the evidence and upon whose credibility it depends, actually comes and gives the evidence. And obviously, the late Mr. Buthelezi cannot do that. So we ask for that to be ignored in the court's adjudication entirely. The remaining 4 documents all form part of a bomb drop of documents that I referred to earlier this morning that took place after the close of pleadings laid down by the court. The court laid down a timetable. Laid down one timetable. Prince Misuzulu came and applied for postponement 3 days before the hearing. It upset that timetable. A new timetable was laid down. The parties complied with that timetable, filed replying affidavits. And after that came this veritable bomb drop of documents in excess of 800 pages, much of it relating to a flurry of other litigation that had gone on, some of it in the form of heads of argument in relation to the 3 applications in KwaZulu-Natal. Now, I won't take the court through it, but the affidavit that deals with that and explains our objection begins at volume 24, page 4737. And the most important part is from paragraph 7 to paragraphs 11. For purposes of time, though, I'm not going to take the court through all of it. It basically tells us in more detail the tale that I've just told about the impermissible late filing of all of these documents. And part of that bomb drop include the signed affidavit of Mr. Buthelezi that was relied on by my learned friend. That is the document that appears at volume 10, page 1895. And if I can ask the court to go there.
So what page at volume 10?
It's page 1895.
Okay.
And it is volume 10. Now, my learned friend referred to this as Chief Butelezi's answering affidavit in Prince Mbonizi's interim intellect application. Now, the problem with that is it isn't. It isn't the one that we've all been talking about as Prince Mbonizi's interim intellect application. If one looks at the top of page 1895, one will see it says in the High Court of South Africa, Gauteng Division, Pretoria. Not from the Pietermaritzburg proceedings. This is another application that was brought by Prince Mbonizi, which, just like Prince Mbonizi's application in KwaZulu-Natal, Prince Makade has nothing to do with. We weren't part of that application. We've never had an opportunity to respond to Mr. Butelezi's affidavit. And it's highly prejudicial if that is allowed in. It's got the further difficulty that our law does not permit evidence from one case to be uplifted and deposited into another case. It becomes hearsay evidence in that process, even if it was made under oath. So again, all the submissions on the basis of the signed affidavit of Mr. Buthelezi, we would ask the court to ignore. The final 2 documents are the affidavits of the purported experts, Professors Ngubani. And again, I'm not going to take the court there, but just to give the references, his affidavit is at volume 11, pages 2060 to 2099, and Mapalala, that's at volume 12, pages 2439 to 2467. And apart from the fact that they were part of the bomb drop there, we haven't had the opportunity to answer to those. There are further reasons why we say they're inadmissible, which relate inter alia to bias and lack of expertise. And that is explained in the supplementary replying affidavit of Prince Makadi at paragraphs 13 to 14.6.2 at volume 24, pages 4744 and following. What then is the good part of the curate's egg? What we say is the good part of the curate's egg is if one sits back for a moment and thinks about the exchanges that have taken place in court, there can be no question that there is a crying need for an investigative committee, as envisaged in Section 8.4, to investigate the breaches of custom that have been debated in the court. And that is the position today, as much as it was the position at the time that the President was looking at the issue as far as the exercise of his powers were concerned in terms of Section 8. If I can then move on to another topic, which is the submission that the President was indeed compelled to act in terms of Section 8.4. We say that insofar as the High Court found that the President's recognition decision stood to be set aside as unconstitutional and unlawful, it is unassailable. As the High Court correctly held, the President was compelled on the clear peremptory wording of Section 8.4 to activate its provisions. To suggest that Princess Thembi's 40-page document did not constitute evidence or an allegation that the identification of Prince Misuzulu was not done in terms of customary law and customs is simply unsustainable. The risk, with the greatest of respect, is that if this court were to hold that that document does not constitute evidence or an allegation as envisaged in Section 8.4, what disputant is ever going to cross that hurdle? Who is ever going to be able to come up with as comprehensive a document as Princess Thembi has come up with in this case? And I would respectfully, safely predict that there are going to be very few people who can muster a document of that nature to make clear their evidence and allegations. There has been a suggestion that there was a failure to identify customs and to identify their breaches in relation to the identification of Prince Misuzulu. We say that if one looks carefully at the documentation, that submission is entirely unsustainable. And unfortunately, I'm going to have to go through the painful process of working through that document to illustrate that. So if I could ask the court to go to volume 13, page 2471. And there we start with her introduction. She says, this document serves to lodge the above dispute by the quintessential section of the Zulu royal family, who are of the firm view that all processes leading and relating to the nomination and or pending recognition and nomination is patently good enough for identification. They're interchangeable. Of His Royal Highness Prince Misuzulu, hereafter Prince Misuzulu, as the King of the Zulu nation, were in violation of the Constitution, customary and statutory law, and therefore of no force or effect. And the point to bear in mind is that what follows, the entire document, the entire 40-page document, is designed to say, here are the customs, here are the laws, and here are the breaches that show that you got the wrong guy at the meeting on the 14th. If we look at just below the paragraph I've just read to you, the heading is Legislative Framework and Disputes. Now, what follows there is a detailed constitutional, legislative, and customary law framework. And this demonstrates that the submission is seriously advanced, by no means frivolous, bona fide, and setting up the foundation for a complaint of non-compliance with customary law in the identification process. If we go to page 2480, which follows that setting out of the legal framework, she confirms this. She says the principles extractable from the above case will be applied after dealing with the issue of Zulu laws of hereditary succession. At this point, and immediately before dealing with the issue of Zulu laws and customary succession, it is instructive to record, and there she refers to Alex Call, the Constitutional Court confirmed the equal status of customary law and that it must now be seen as an integral part of our law. It further held that, like all law, it depends for its ultimate force and validity on the Constitution, and so on. Then it says, under the heading hereditary succession, both the national and provincial legislation recognize two types of leadership positions so far as traditional leadership is concerned. And then at page 2483, the evidence is given at paragraph 1 that the nomination and appointment of the late Queen contravened customary law. And this is important. This is important. Yes, it is so that the Queen never got to fulfill the position that it was suggested she should fill. But her being nominated by the King and her in turn nominating Prince Misuzulu formed a crucial part of the sequence of events that resulted in the wrong identification of Prince Misuzulu. So it was important that they explored that part of custom and why there wasn't compliance. Then at paragraph 5 of that page and on page 2484 at paragraph 8, she gives her evidence that in terms of custom, the heir has to be a direct descendant of the king through a direct line of descent. And as we're reading this document, we must bear in mind who it's coming from. It's coming from a very senior, experienced member of the royal family. So these aren't just allegations. Our law recognizes that somebody in that sort of position is entitled to give testimony that's admissible about the content of customary law. So paragraph 5 and on page 2484 at paragraph 8, she gives her evidence that in terms of custom, the heir has to be a direct descendant of the king through a direct line of descent. And then at pages 2486 to 2487, she sets out her evidence pertaining to, and I quote, the position of the great wife and the customary rules of succession, and concludes that, and I quote, her position of being a great wife in terms of the Zulu law of customary succession is not being contested. It's all referenced to custom. Then, and again, not contesting that part, shows that, again, the bona fides. They're saying, we accept that, we go along with what was with the fact that that is the house that the appointment comes from, but she then moves on to where her differences are. Then at page 2487, she says, second last paragraph, a further consideration of an heir relates to the matrix of the custom of ukufakwa esiswini. It was the portion that Justice Nichols referred my learned friend for the President to. And then she goes on to describe in great detail, under the heading, the custom of ukufakwa esiswini, and describes it. I won't read it all out. But crucially, in the concluding paragraph, she says, it is therefore submitted that Prince Simakade Jackson Zulu, Isekwangwangani, to His Majesty, is the rightful heir to the throne of the Zulu nation through the custom of ukufakwa esiswini. There you have it. She is saying that is the custom that has been overlooked and has been breached. It's all there. Even if we stop at this, if the letter had stopped at this point, it was sufficient to activate Section 8.4 of the Traditional and Khoisan Leadership Act. But she goes on and says more. At page 2490 to 2491, she testifies about the respective customary positions, ranking, and powers of the senior prince and the traditional prime minister. So at the bottom of page 2491, second last paragraph, she says, having regard to the contents in this subheading, it follows from the concise exposition herein relating to the processes forming the subject matter of this letter that any conduct and or act performed contrary to the accepted customary position in this regard is ultra vires and of no force or effect. So again, she's setting up the framework. She explains how these two positions rank in relation to each other, the senior prince and the traditional prime minister, and what their respective roles are. She gives the framework, and then later she's going to go on and say where custom was breached. And that she does at pages 2502 to 2508, where she takes the reader in our case the President, through all of the events that led up to, the disputatious events that led up to the identification of King Misuzulu. And one must read that against the backdrop of her exposition of what the correct roles are of the senior prince and the Prime Minister. And wherever they differ, there is your breach of customary law. She then concludes...
All right, Mr. Dodson, your 20 minutes of immunity is now over. I just wanted to give you time. I didn't want to break for tea before you have exhausted your 20 minutes. So when we come back, we're going to adjourn now. It's 10 past, so we'll be back 25 past, then we'll proceed. But your 20 minutes is up now. All right, thank you, the court adjourns. Yes, may I proceed, Mr. Dodson?
As the court pleases. Deputy President, I was dealing with the letter of Princess Tembi. If I can refer the court to page 2509, and that is her concluding submission, which we respectfully submit seals it in terms of section 8.4. She says, having regard to the foregoing, everything she said in the previous 39 pages, it follows that at no stage was Prince Misuzulu identified, she uses the correct word there, and or nominated and accepted by the royal family for the purposes of being recognized and appointed as the one to ascend the throne. Throne being a customary throne, for the following reasons. A, the meeting of 7th of May did not amount to the meeting of the Zulu royal family as defined by both the national and provincial legislation as per the constitution of the meeting recorded paragraph 11. Let me just pause and make a point there in relation to royal family. Yes, royal family is statutorily defined, but it provides for each community, I respectfully submit, a template. And the template is filled in using the customary law of that particular community. So one can't just say because royal family is a statutory thing, that's not an issue of customary law. It is. It specifically envisages the infusion of customary law to give effect to that definition. So she says it wasn't the royal family. B, the meeting of the 14th of May was called under a false pretense, and the agenda thereof does not depict that it was called for the purposes of identification, as set out in 81A1. C, it is vehemently averred that having regard to the preceding paragraphs, Prince Misuzulu cannot be recognized, appointed, and be coronated in terms of the Constitution, customary law, and both the national and provincial legislations. It is vehemently further averred that the decision to identify the king rests with the family in terms of the Constitution, customary law, and both the national and provincial legislation. So, really, as I say, that places it square and centre in section 8.4. The other highly relevant evidence is the appointment of the mediation panel by the minister after the minister was asked by the president to give advice, as well as the report that emanated from that ad hoc mediation panel. And the very name of the panel, it's the ad hoc mediation panel for the AmaZulu kingship dispute, already tells us a story about a dispute of the kind envisaged by section 8.4 being on the go. The panel's terms of reference, I won't take the court to them, but if I can just give the reference for them, 2963 to 2967, and that would be in volume 15. And they refer to Princess Tembi's letter, to the letter from Strauss Daly, and to a letter from Prince Misuzulu himself, which demonstrates, and I quote, there exists disagreement within the AmaZulu royal family regarding the succession to the throne. There are also very important, extremely important findings and recommendations in the report of the mediation panel. And we say these findings on their own confirm unequivocally that section 8.4 was applicable. And bear in mind that that mediation panel that was appointed included customary law expertise. That is dealt with at the parts we rely on pages 501 to 507 in volume 3. And if I can ask the court to go there to page 501.
Sorry, volume 3.
Volume 3. 501.
Okay, proceed, yeah.
At paragraph 4 on page 501, the report says the meetings held by the first group, that's Prince Misuzulu's group, on the 24th of March, 30th of April, and 14th of May, importantly, appear to have not met the requirements of the legislation. They were mainly to deal with the implications of the will, the issue regarding the regent, and to introduce Prince Misuzulu as the king-elect, as the nominated successor, and for attendees to recognize him as such. It appears it was already a fait accompli. The second group meeting on the 4th of May and the 23rd of May, now referring to Prince Simakadi's meetings, they've got the date wrong by 1 day, seemed to amount to substantial compliance with the legislation, in that there was a proposal of the nominee and then support for the same. The nominee explained the custom of ukufakwa, thus giving the reason for nomination. Next important finding is at page 503, starting just above 8. In the middle of the preceding paragraph, it reads, so first and second groups are correct with pointing out at Kangela as the palace/house to produce an heir. What separates them is the adoption and inclusion of Prince Simakade as heir at Kangela and the disqualification of Prince Misuzulu from becoming the king. This legal exposition addresses the concerns raised during the meeting of 20 November. Succession to kingship, queenship, or traditional leadership is currently based on birth, gender, and status of the wife. Also excludes the nomination of the third group, the 3 princes from Dlamatlala and the first wife of Naleni/Keta. Proof of evidence of ukufakwa of Prince Simakade. According to the second group, Prince Simakade moved from Keta Naleni Palace to the palace of the first wife and stayed at Kangela for several years. Prince Simakade performed Ilibomvu custom, Swazi custom usually practiced by females to be attached to their mothers. This implied his attachment to Mtani Nkosi. The late queen referred to Prince Simakade as her first son, as he was her biological child in the textbook by Prince Zebron Zulu. There was a misunderstanding between the late king and queen when the late queen wanted to remove Prince Simakade from her ukumkipa. The late king was pleased with Prince Simakade when he got married, and like Prince Misuzulu unmarried, according to Ondlunkulu, the Prince Simakade is helpful and respectful. And in fact, what one sees coming out of their report is that there was, in the latter part of, in their latter years, it seems that there was tension between King kaZwelithini and Queen Mantfombi, which may have impacted some of the things that she also said about Prince Simakade.
Mr. Dodson, in your head of argument, you say that the report or the mediation panel was unlawful and contrary to the requirements of the Act. So,
yes.
So what weight must we attach to the findings of the mediation panel?
Well, it's got a de facto significance. One can't agree. It wasn't the right thing to do. The correct thing for the president to do was not to appoint this mediation panel. It was to act in terms of Section 8.4 and get on with it. Appoint an investigative committee and let them do it in terms of the statute. But for better or for worse, it wasn't done. The reality is that a group of people with customary expertise gathered evidence, and this is what came out of it. And at the very least, if the minister was going to appoint this mediation panel, the president should have used it. Should have used it was important information relevant to the decision in terms of Section 8.4. So, indeed, I could see de jure, it didn't have a status. We submit de facto.
Sorry, Mr. Dodson, my sister has got a question for you.
I beg your pardon.
How is the evidence if you say you gathered the evidence was just a recording to answer to the questions that they posed to them, or were statements made under oath? I think the question that my sister is really relevant. What weight should we attach to this?
If I'm hearing your question correctly, what was their methodology in terms of evidence gathering? I don't know what their methodology was, but I think if one looks at it more carefully, it's probably is revealed. I think there were interviews that took place. I think that was the main mechanism. But I would submit it's evidence nonetheless. Yes, it took place in terms of the process that should have happened, but we submit that it is evidence or an allegation, as envisaged in Section 8.4, that the President should have had regard to. A. B. It's also a comparator, if I can put it that way. It's a comparator as where another group of people assess the situation and come to a conclusion very different. And what I'm going to refer the court to, importantly, is what they say at paragraph 507. In paragraph 507 they say, in paragraph 11.5, it is deemed by us as the panel that before the President implements any person, he ought first to investigate through a legally formed investigation team. Issues to be investigated must include whether Prince Simakade and Ilibomvu is true, as well as his institution into the Container Palace. If true, can it be undone or overlooked when the appointment is made? Remembering that Queen Montformby is known to have tried to persuade the installer, the king, but only managed to anger the king. It was therefore never done. So to elaborate on my answer to your question, this doesn't need to be conclusive proof of these issues. All it is evidencing is that there was evidence and allegations that the identification of Misuzulu was not done in Pretoria custody. And this,
So you say this passes the 8-4 threshold, is that it?
indeed. And they thought about it themselves with reference to 8-4, and they said they recommended that he apply. And in a way, maybe it's wrong for me to make the complete concession that it has no legal substance. It would seem to me that the president or the minister is entitled, without following a particular statute, to get a dispute settled or to gather information. And the product of that could be relevant to what was the correct statute to apply, which was Section 8.4.
But, sorry, that mechanism is not a mechanism that is provided for in the Act.
The mediation mechanism.
Yes.
Yes, I concede that there's nothing in the Act to provide for mediation, and I think the point of the pleading that we made was to say you haven't complied with Section 8.4, and don't come and tell us that your mediation panel complied with Section 8.4 because it didn't. It wasn't compliant. I concede that, and I accept in fact made that as part of my case.
Sure. Tell me, there are some documents which you ask us not to consider. Apparently, there was an application to have them struck off in the High Court.
Yes, there was.
What happened to that application?
It was advanced, but it just wasn't dealt with in the application. It wasn't dealt with in the judgment.
Well, is it before us?
Yes, it's if one looks at our notice of appeal, it is before you.
Well, I saw it, but is it properly before us? Because there must be an appeal against the order. Where is the order? You appeal against the order.
Well, you can also appeal against a failure to grant relief. And I think if one looks at the judgment of the Constitutional Court in Luke Tembani, a case involving the Zimbabwean farmers, I think they make that point. When we apply the rule that to appeal it has to be an order, you can also apply it in respect of relief that you asked for but was never dealt with. That was never contained in the order. And we asked for it, isn't there?
You are before this court on the leave granted by the court below, is that so?
On the leave granted
Yes.
by the High Court.
Yes. So for you to be in this court, you need leave of that court. That's how the mechanism of the statute operates.
Yes.
Yes.
I can't say I've looked at the leave judgment to see whether they canvassed it.
So if it wasn't dealt with, if the leave that was granted by the High Court did not include the leave to appeal against whatever decision that you are appealing, then you are not properly before us, insofar as that issue is concerned.
I think one would have to look at the wording of
Sorry,
So the order reads, leave to appeal and leave to cross-appeal as applied for by the respective parties against the orders of this court of 11 December are granted to the Supreme Court of Appeal.
Yes, but if you read Judge Davis's judgment on leave to appeal, that is not addressed.
It may well not be addressed, but he's granting it with reference to our applications. If one looks at his order, he's granting it with reference to our applications. paragraph 12, this is
Sorry, let me
of the
just...
leave judgment. She says, having reached the above conclusion, I find it unnecessary to further dissect the various applications, irrespective of my view of the lack of prospects of success on appeal or not of some of them. And then he gives the omnibus order. So we submit that that was an omnibus grant of leave to appeal on an issue that we did raise, and he said he was giving it on an omnibus basis, and it was then carried through into our notice of appeal, which is in the supplementary volume at 4918. And paragraph 5 on page 4918 says that we're appealing against the dismissal of Prince Samakadi's first and second applications to strike out. So we submit that that order is indeed before the court.
So I'm just looking at Prince Simagade's application for leave to appeal.
I don't have the paper. I respectfully inquire of the page number, Deputy President.
I've got it there. I'm just looking at it.
Don't get 4829.
4829, paragraph 4.
Paragraph 5.
Okay, strike out, yeah. Then I just want to look at the High Court's judgment on leave to appeal. Leave to appeal and cross appeal applied for. All right. But there is no specific order dealing with the application to strike out.
We say it's included in the omnibus, but it isn't specifically articulated, and is specifically articulated in the notice of appeal. Moving on from the submissions relating to the mediation panel's report, what we say is that the papers in the matter also demonstrate that there is a wealth of evidence, substantial parts of it uncontested, which can be adduced before the President's investigative committee to back up the evidence contained in Princess Tembi's submission and in the mediation panel report. And just to give two examples of that, for example, if one looks at paragraph 92, which is Prince Samakadi's founding affidavit, page 2718.
Volume?
And 2718 is in volume 14. And there he describes, and I'm not going to go through all of it, but just part of it where he speaks about his affiliation with the house of the late Queen Mantombi Dlamini, and the great wife of Lady Silo, was confirmed by Mr. Nzimande, that's Mr. Temba Nzimande, in his book King Mpande's Children. On page 40 he lists the great-great-great-grandchildren of King KaZwelithini's, including those born of the late Queen Princess Mantombi Dlamini, as follows: A. Misuzulu, B. Ntando Isizwe, C. Nomkosi, D. Bukosi Mbelo, and so on. And then a heading, affiliated, A. Simakade, added. And that book has the endorsement of both King kaZwelithini, I think he wrote the foreword, and it also has the endorsement of the late Mr. Buthelezi. He also has something to say in the book. So it's not an issue we need to prove in these proceedings, but it's a demonstration that this is a serious contest that is there to be put up in front of the investigation committee. Another example, if I can refer the court to, and I should just add in relation to that, there was a strikeout application brought by Prince Misuzulu in respect of some of the evidence put up by Prince Simakade. This was not part of it. This is not part of it. So this is essentially uncontested. Then there was another example is the analysis that was done in relation to attendance at the 14th of May meeting by Prince Simakade. So what happened is the initial sheets of attendance registers were illegible. They were in handwriting, poor copies. But with Prince Misuzulu's answering affidavit, he put up typed versions for the first time that enabled those to be checked and analyzed. And if one goes to Prince Simakade's replying affidavit at volume 22, page 4312.
Page
4312. I beg your pardon, 4311. I beg your pardon, 4311.
Yes.
So it starts at 69. In paragraph 5.20 of the answering affidavit, it is averred that all those who attended the meeting of 14 May were members of the royal family, as per the mandatory requirement of Section 8 of the Leadership Act. I strongly refute the assertion that all those who attended the meeting were members of the Zulu royal family, as per the mandatory requirement of Section 8 of the Regulatory Act. Many persons purporting to be members of the Zulu royal family who attended and participated were disqualified from attending and participating in terms of the second respondent's own definition of who forms part of the Zulu royal family. He refers to when he did it in his founding affidavit. There was an initial shorter list where he could recognize people, and then he picks up two people who are problematically included, and then 71. Indeed, an analysis of the attendees reveals a number of errors and misrepresentations of lineages of the attendees. Paragraph 7.12, the second respondent who asserts that the houses of the Zulu royal family, which are central to the decision-making process of the identification of the successors to the late and form part of the royal family, the five preceding kings are those from the royal houses of Ketshwayo, Dinizulu, the royal house of Solomon, the royal house of Zulu, and the royal house of SCA. However, the attendance registers annexed reveal that many of the attendees misrepresented their lineages, including Prince Buthelezi. This manipulation of lineages has the effect of purportedly bringing within the fold many members who ought to have been excluded from the royal family's deliberations. These members ought not to have participated in the decision-making process of the identification of the successors. Scrutiny of the transcribed attendance registers forming annexes to the second respondent's answering affidavit yields the following. And then he goes through and does a detailed analysis, detailed close analysis, to show where those are misrepresented, including starting with Prince Buthelezi and his daughter, Princess Phumzile. But he then works through, and I'm not going to take the court through all of them, but I commend it for the court's consideration, because it's carefully and logically reasoned in relation to each of the people that he deals with on that attendance register. And at page 4319, paragraph 74, he then draws the following conclusion. Having regard to the above, it is clear that the majority of the attendees who attended and participated in the purported identification meeting of the second respondent are not qualifying members of the Zulu royal family, as defined by the second respondent himself, last five kings, and or as set out in the Leadership Act. So that on its own, if we consider the finding of this court in the Mpepu judgment, which says that the wrong people participate in the decision, it invalidates it.
Sorry, the decision of this court is?
Mpepu versus Mpepu. The wrong people participate in that process. That's the end of it. That leads to invalidity. And that's invalidity both in customary law, effectively, and in administrative law, and in constitutional law.
Mr. Dodson, with regard to Prince Mbonisi's allegations, I presume you part ways with him. He says that there's no great wife. Anyone can be a successor, daughter or son. Ukufaka esisweni didn't happen regarding Prince Simakade. because the brothers would have been. In any event, it's irrelevant according to him. Now, how do you respond to that?
We part company with that. We part company with that. And in fact, it's wrong to say that they disagree with Ukufakwa, because there is in fact a section of one of Prince Mboni's affidavits where he confirms the Ukufakwa and says that he was involved in doing in ensuring that the relevant ceremonies took place. We'll find the reference for you. I don't have it immediately to hand. But we pleaded a case, and we stick to our pleaded case, which is based on both Misuzulu and Simakade come from the house of one, and that's the source of the king.
So he says, Prince Mbonisi says there's no custom that the firstborn child is the predetermined heir. Do you agree with that, or do you not agree with that?
It's primogeniture. There is indeed such a custom. What I would accept is that that is the custom. But my experience in these cases, my reading of anthropology tells you that sometimes exceptions are made. So when I say that, I'm not saying it's absolutely hard line, because in fact one comes up with situations where primogeniture doesn't reveal an obvious candidate,
But your case here is that primogeniture is being followed, and the first son is Prince Simakade, according to Fagoi Esiswe.
Yes. That's up.
Well, let's say Judge Davis was correct in the court below to set aside the recognition and direct the president to establish the investigative committee. Prince Mbonisi says, the matter should have been diverted to the royal house. That's what he says, Prince Mbonisi. He doesn't want a diversion to the investigative committee. He wants the matter to go back if the decision is set aside to the royal house.
Well, it seems to me that, and my junior counsel will kick me if I'm making the wrong submission here, but it does seem to me that if one follows the logic of the relief they seek, which is that they want to undo the decision of the 14th of May, if that is set aside on review, then it may well be that the only logical relief that flows from that is that it has to go back to the royal family.
Okay.
But that's not our position. Our position is that yes, we agree with Prince Mbonisi that 14th of May meeting was fundamentally flawed. But we say that's a reason to apply Section 8.4. Part of the reason to apply Section 8.4, that was one of the customary failings, was that meeting going wrong. And we say it must be channeled, and in fact we say that the legislature, the Section 8.4 provision is interesting. As we saw from the Chibumo case, the previous wording of the National Local Government Traditional Leaders Framework Act said may also.
And this one says must.
So the legislature switched it to must. And there's a presumption that when the legislature changes the language, they intend to change the meaning. They want it to work differently.
Yeah.
And they changed it to must. And what it seems to us that suggests that what the legislature wants is that these disputes must be channeled into that investigative committee process. And that's where they must be dealt with. And there's an enormous amount of sense to it. It means that festering disputes don't go back to a place where the festering started. They get channeled into a professional dispute resolution situation. They get dealt with through investigation. It can be a public process that has accountability and transparency, and hopefully one gets to a resolution.
Well, but that approach on Prince Mboni's argument, it's not an approach that will give effect to the rights of the royal family to identify, because that's the basis upon which he feels the royal family has been aggrieved. It wasn't given the right to identify, to participate in the identification process. So, what do we do here? Well,
we respect that. There's an entire. The fact of the matter is, the president made his decision. So the handbrake that this court laid down in paper, where they said the handbrake stays on until the recognition decision has taken place. Once that's taken place, the handbrake is off for both the identification decision and the recognition decision, and the identification decision becomes part of the administrative action that is subject to review. There's in fact an incorrect submission in Prince Misuzulu's heads that administrative action doesn't relate to the identification process. It does, but it's only perfected once the recognition decision has been made. So we respect it. We originally, I should say, in fairness to Prince Mbonisi, we originally also challenged on review the identification decision. But we realized that would channel it back there. And our concern about going back to the royal family is there is a real risk of more disputes and more litigation. You look at the papers in this case, Deputy President, we don't agree with each other about what how the royal family is constituted. But there's potential, if we go back to the royal family, with all due respect to Prince Mbonisi, for this thing to really drag on and drag on and drag on. That's why we
as well as on whether or not there is a customary law and custom according to which the identification should take place. Because according to Prince Mbonisi, there is no sort of established custom.
I beg your pardon, there's no
established custom. It's very fluid, if I might put it that way. It depends on the situation.
If it's fluid, then it illustrates the point I'm trying to make, because if it's fluid, it's going to generate more disputes. The advantage of going to the investigative committee is that they struggle with that part of the customary investigation related to identification. They're entitled to move on to the substantive question of who should it be, Prince Makade or Prince Misuzulu. And they can get on with it, and they can come up with the result. What we do ask, and what Judge Davis did not give to us, is that there be mechanisms in terms of Section 81C, I think it is, of budget, that ensure that the process is fair. We have to remember we started off here with a wrong decision by the President, aggravated by the fact that he has, both in public and in these proceedings, openly sided with Prince Misuzulu. That's a problem. That's a problem, because he is in charge of that dispute resolution process. He appoints him, they go and report, they come back to him, they deliver their report to him, and he, in terms of 8.5, makes the final decision. So that's a worry. We say that's what Judge Davis should also have included in his judgment and didn't include, is to ensure that all of the parties, Simakade, Misuzulu, Mbonisi, they all have an input, protected by a court order, to comment on who's chosen for the investigative committee. They all have an opportunity to obviously give evidence before the investigative committee. They all have an opportunity to comment on the report that emerges from the investigative committee. So that is provided for both through the channel we discussed earlier of the application for leave to appeal and into the notice of appeal, and we set out a draft order in the notice of appeal which provides for that.
And the investigative committee, the composition thereof, that's the prerogative of the president, we say.
That belongs to the president, but we say we build into the draft order a mechanism for him to say, here's my proposal, you've got X number of days to comment, and then I'm going to make my decision. If I can then just make a brief submission about the wording of section 8.4 insofar as it uses the words evidence or an allegation. We say that the fact that the legislature used two words and not one needs to be respected because there's a presumption against tautology. The definition of allegation in the shorter Oxford English Dictionary 2007, that's in fact the big one even though it's called shorter, is as follows, and this isn't in our heads. It is, first they say the action of making a charge before a legal tribunal, a charge so made, or, second meaning, an excuse, a plea, and alleged reason. Third reason, a claim or assertion of wrongdoing, especially one made without proof. So we say that that too points to two possible triggers that can set it off. You don't have to, if one has regard to that interpretation of the word allegation, you don't have to actually come up with your evidence to be able to enable the president to activate section 8.4, as long as there's at least an allegation. So if the court is against us in relation to the letter from Princess Tembi on the basis that it doesn't contain evidence, we say it does, and what she says is recognized evidence, but if the court is against us, it certainly falls under the category of an allegation as defined.
Well, but Mr. Dobson, I think that the allegation must be such that it constitutes a sufficient basis for the president to conclude that there was the identification was not in accordance with custom. Well, I'm sure that would be a threshold. Otherwise, then you allow any vexatious.
Yes, we would concede that what we would submit is the interesting case is Chibumo, because Chibumo was a higher threshold because it required the president to exercise a discretion.
Yes.
But even there, if you look at what happened with the Chibumo family were a headmanship or headwomanship. In fact, they had a head woman before. And what the court pointed out is that you, Chibumo headmanship or headwomanship, can't claim to have a royal family because the legislation is built around traditional communities, not headmanship/headwomanships. So you can't have your royal family. So your case that you came with on the basis that you were the Chibumo royal family can't fly in terms of the various definitions in the Traditional and Khoisan Leadership Act. But the court was still willing to say, Premier, you should have referred that to the national houses for their recommendations because there was a customary law dispute. So we say the threshold is low, and there's nothing wrong with Judge Davis's having said that the threshold is a low one. And if there is any evaluative process, it would only go so far as saying, is this on the basis of Chibumo, is this vexatious or is this frivolous? And yes, I would concede that the president would be entitled to filter those out of the process. But I think the legislature wants to get these disputes into a formal dispute settling mode rather than letting them fester in the way that even this one is also festering terribly. So those are the submissions in relation to the wording of section 8.4. An issue that I wanted to deal with because it came up yesterday is the issue of Prince Simakadi's letter of the 11th of May. And we most respectfully submit that, again, Prince Simakadi's letter is being misunderstood.
Well, what does what does he want to convey in that letter? What is he saying? Is he saying I'm available or I'm not available? What is he saying?
Well, there's a whole lot of things. Like,
It's very it's very ambiguous.
what?
It's
if
just
I
like
can-
a person
if I-
who's sitting on the fence.
Can I be allowed to answer it
Yes.
like a lawyer? And that is to say, context is everything. And I'd like the court just to bear with me to provide the context as set out in his founding affidavit, because I think it provides a firm basis on which to understand what the meaning of the letter was. So if we go to page 2730, which is in volume 14.
Yes. You are there?
So he describes the developments. He says the late Queen passed away on 29 April and the memorial service in honor was hosted at the palace on the 7th of May 2021. At the end of the memorial service, Prince Buthelezi stood up and announced to those present and to the media that he had been called by the lawyers for the late Queen, requesting a meeting in order to read the final will and testament that the Queen had left. He announced that the meeting would be held that same evening, 7th of May, at the palace, the late Queen's palace, and the venue where the memorial service was held. Accordingly, a meeting was opened to the public and screened live on TV. Will was read by Advocate Griffiths Madonsela. He informed all present that the late Queen had nominated Prince Misuzulu as the next king of the Zulu nation. This gave rise to a number of queries and concerns as to the legal validity of the Queen's purported nomination and its status. The meeting descended into chaos as Prince Buthelezi denied members of the royal family a chance to ask questions, and police were called upon to remove Prince Thokozani of Kwantla Matlala, although ultimately they did not do so. No one else was allowed to speak in that meeting except for Advocate Madonsela and Prince Buthelezi. Prince Buthelezi announced that the succession debate was closed. The following day, 8 May, Prince Buthelezi again addressed the media and reported that the matter of succession had been settled with the reading of the will, and as far as he was concerned, the king is already on the throne. Prince Misuzulu was addressed by Prince Buthelezi as the king and given the Bayete salute that only kings are given. Thereafter, on 9 May 21, the Premier of KwaZulu-Natal visited the palace, purportedly to pay his homage to the newly announced king. I understand that notwithstanding that there had been no identification decision by the royal family, the Premier brought cattle with him, which he presented to Prince Misuzulu. On the 10th of May, the KZN's Premier's spokesperson, Mr. Lennox Mabosa, is quoted by the media as having said that the Premier will announce the date for the coronation of King Misuzulu. I was not involved in or consulted about any of the foregoing developments at the instance of Prince Buthelezi. I knew that the customary procedures for identifying new king had to take place, and were taking place, and I assumed that everything was being done lawfully in this regard. I did not participate in any meeting of the royal family to deal with the issue of succession, although I attended the subsequent meetings of 23 May and 5 September 21. I highlight in this regard that recognition of the successor is not a matter of voting or candidature, but a matter of the proper application of customary law. While I was trying to come to terms with events, and following upon announcements in the press and press coverage, I received a barrage of calls from the media, supporters and other members of the public. I preferred not to deal with the media. I therefore decided that it was in my best interests and those of the Zulu nation to ask Prince Buthelezi to intervene with the media, given his function as the spokesperson on certain matters affecting the Zulu nation. I therefore decided to address a letter to him. On the 11th of May, and against this background, I addressed correspondence to Prince Buthelezi, indicating my intention to abide what I understood to be the decision of the royal family. I quote this letter in full, as it has respectfully been misused and misinterpreted against me. I annex a copy of both the Zulu version and a sworn translation of the English translation of the letter, together with a certificate from the sworn translator, Sorrel Language Services. The court will have seen that the other version that we were looking at was a Strauss Daly production, the attorneys for Prince Misuzulu at that stage. We submit that this translation is the one that must prevail, because it has been prepared by a sworn translator. And then he reads the letter, and I'll come back to the letter. Then in 125 on page 2734, he says, I emphasize that I wrote this letter in the past tense on the assumption that a proper process, both statutory and customary, had been followed. and that the outcome which I was bound to accept if the process was properly conducted was that Prince Misuzulu had been appointed as Isilo. Had I known what I subsequently discovered to have happened, i.e. that neither the correct customary law nor the correct statutory processes had been followed for the appointment of Prince Misuzulu, I would not have sent the letter, at least in the form that it was. As the letter clearly conveys, if there had been a proper process and I had been nominated, as I ought to have been, I would have accepted my nomination to the position of king. Now, questions have also been asked about why, if there'd been this meeting on the 5th of May, he wasn't talking about that in this document. To get the answer to that, if I can ask the court to go to 4305.
So what,
4305, and that is in volume 22. Sorry, 4304. 4304 in volume 22.
Yes.
Reading from paragraph 50, the allegations around the secret meetings. The second respondent in paragraphs 15.3 to 1540 and elsewhere makes certain false statements pertaining to what he asserts were secret meetings that were orchestrated by my supporters to identify me as king. These averments are false, hearsay averments, based entirely on the draft affidavit of Prince Buthelezi. They will be included in the striking out application. Suffice it to say that I stand by what I said in my prior affidavits regarding the meetings, giving rise to my lawful identification as king. The attempt to cast suspicion over the meetings by describing them as secretive and orchestrated is contrived. They were properly called and conducted. The precise nature of the meeting of the 5th of May 2021 is set out in my founding affidavit. It took place amongst the most senior members of the royal family, and this is entirely consistent with custom. Prince Buthelezi is not part of the senior members of the royal family. 15 of such members attended. They are listed in paragraph 106 of my founding affidavit. As is pointed out in the founding affidavit, although I was nominated there were additional members of the royal family from other houses that were not represented at that meeting and who needed to be consulted. A wider consultation was agreed to take place at the meeting of the 23rd of May. There was also a delay, this is the important part, there was also a delay in the outcome of the meeting of the 5th of May 2021 being made known, again consistent with custom. Even I did not know the outcome for some time, and that is in part why I was under the misapprehension when I wrote the letter of 11th May 2021 that the outcome of the identification process had been against me. So if I can ask against that backdrop, that we then return to the letter at page 2733. Unfortunately, these references aren't in our heads of argument because the issue has come up in the course of the debate yesterday. But I can ask the court to go back to the letter at page 2733 in volume 14. And if I can ask the court to start at the end, the bottom of the letter. Says, I request the Prince, as he reads the statement in its unaltered state, to also ask the journalists to desist from calling me about this matter, because there is no further information I can give in addition to what I have already stated. So
when he writes the letter, he's already been nominated by the meeting of the 5th of May.
He doesn't know about it.
He doesn't know that he's been nominated by the 5th of May.
He doesn't know about it. That's the paragraph I've just referred to in the replying affidavit. He doesn't know he's been nominated. It's also important to bear in mind that already on the 5th of May, they recognized that the identification was incomplete. In fact, his identification process involved 3 meetings. 5th of May, 23rd of May, and I think it's the 5th of September. Those 3 together give rise to the identification. He does not know at the time of this about what has happened on the 5th of May. And I can't remember why they were described as secretive, but it kind of ties in a little bit with that averment. So well,
sorry, This letter is written on the 11th of May. The statement is dated the 11th of May, which I assume is the date on which it was written. The meeting at which he was nominated took place on the 5th. So between the 5th and 11th, he was in the dark as to
Indeed.
the outcome of the meeting.
Indeed, that's his uncontested evidence. So his problem is he's getting pestered.
But hang on now. You've got a situation where a person does not know whether or not I was nominated, but he is worried. He asked President Cyril to say, please intervene here. Why is he so worried? Why is he worried? Was it to understand that he asked him to read the statement?
Because he's being harassed by the press. And Prince Buthelezi is the logical person to deal with the press. That's what's clear from this last paragraph of the letter. I request the Prince Buthelezi, as he reads the statement in its unaltered state, to also ask the journalists to desist from calling me about this matter, because there is no further information I can give in addition to what I've already stated. Then please leave me alone.
Well, there's somewhere where he says that I'm aware, Makeba, that there are rumors suggesting that there may be people who wish that I should take the position. So there's something that he knows. He's aware of something.
He's heard rumors.
What is the nature of those rumors? And where do they come from? Is it from the media or from...
No, he's saying... He's obviously getting pestered by the press, and he says in the first paragraph, I request the Prince to read this open statement on behalf of it is. He's not saying anything about any meeting that's coming up or anything like that. He's saying, I'm being hounded by the journalists. You're the guy who deals with journalists. Please read this. It's a press statement. He's saying, please read this press statement to the journalists.
He's nominated on the 5th. He hears these rumors. He doesn't go back to anyone and say, hey, what happened at the meeting of the 5th?
Because he doesn't, I don't think he knows about the meeting on the 5th. I don't think he even knows about the meeting that took place on the 5th.
Doesn't anyone tell him that he's been nominated as a successor to be a king? Doesn't anyone tell him that?
That's his uncontested evidence that at the time that he wrote this letter, nobody had told him that he'd been nominated.
Not even the elders in the family?
Not even the elders. And there was a good reason for them not to tell him, which is that the process was incomplete. More people had to be consulted. Another meeting had to be held. It might well have gone against him in the subsequent meeting. So the letter is perfectly logical, and it in fact reflects a respectful person from his generation, which is below the decision-making generation. And he says, I'm aware that my name is mentioned in some narrative that I have ambitions of ascending the throne. He said, I was thrilled when I saw the Prince stating on television that I've never told him that I covet this position, and I confirmed what he said. I confirm that I have not told anyone that I covet this position. I'm aware that there are rumors that there may be people who wish that I should take this position. I cannot do anything about other people's feelings.
But isn't this, that this might be what he's talking about the 5th of May? That there are people who are suggesting that I take this position.
It might be that those are the source of the rumors. He acknowledges the rumors, but he says, and it's a disciplined position. It's a respectful and disciplined decision, which he goes on to explain in the next paragraph. I want to state that my aunt, the princess who is married to the Ndlovu family, I think it's Princess Tembi, and the Prince of the Kwezi house have advised us as the king's children that if the king or queen chooses one of us, the one who is nominated should accept the nomination. Therefore, I would have accepted the nomination had I been selected. And they had also advised that we should accept and support whoever is nominated. And bear in mind, there's been a sequence of meetings that he is aware of, where Misuzulu is the person who's been appointed as king.
Well, according to the instruction that was given to them by his aunt, Princess Tembi, to say, you must be behind whoever has been nominated. Why was he not behind Prince Misuzulu?
Because
As per the instructions by your aunt.
at this point he was. And he's saying, at this point effectively he was.
What changed then?
He was saying he'd been told by Princess Tembi
Yes.
that if the king or the queen chooses one of us, and the queen in fact chose one of them, they must accept it. At this stage he's accepting it. He's entitled to discover later on that without his knowledge, there's been a process underway in which people actually want him. And he has confirmed in this letter, to say, therefore I would have accepted the nomination had I been selected. He's entitled to say that. And let me take the court to where...
Okay. At what stage then did he become aware that King Misuzulu had been nominated?
I'm not exactly sure, but he attended the meeting of the 23rd. So certainly...
Because you've got a situation where a person has been... There are standing instructions from the senior member of the family to say, you must be behind whoever is nominated. In due course, King Misuzulu is nominated. In accordance with the standing instruction given by the senior member of the family, one would have expected him to have complied with the instruction by supporting the nomination of King Misuzulu.
And that's
why did it happen here?
And that's exactly what he's doing here. He's saying, read a press statement, not, by the way, use this letter to read out at some nomination meeting on the 14th that I don't want this position. That is not what this letter says, by any stretch of the imagination. And I'll show where that misconception comes from. It comes from the unsigned affidavit of Mr. Buthelezi. He's saying, read a statement to the press. He's behaving in the way that he's been told to behave. But the reality is, in the background, there is a process underway that he is unaware of that wants to nominate him. He's got a letter on record on the 11th that said, had I been nominated, there's been a series of meetings which suggest that he's not nominated, that Misuzulu is. And he respects that. He even goes as far as getting this press statement read to say to the press, leave me alone.
So on his version, he became aware of the competition, let's call it, between him and King Misuzulu was on the 23rd of May.
I don't know. I'm speculating. I know that he attended that meeting, so that must be the latest point at which he'd become aware of it. I don't think it's on the paper as the point at which he did in fact become aware of it, but certainly by the 11th that he had not. And if I can just take the court to the unsigned affidavit of Buthelezi, because we see where all the confusion is being generated around this letter. The court will just bear with me to find the reference. It's 3827. Volume 19. 3827, volume 19.
Sorry, what's the page number?
The page number is 3827 in volume 19.
Must be volume 20.
It's 20. 3827.
Volume 20, 20.
Yeah, it's volume 20. Yes.
So what is purported to have been said by Buthelezi in an unsigned affidavit is, however, in the days leading up to the meeting of 14 May 2021, there were rumors, principally from the media, that Prince Makadi was mooted as the possible contender for the heir to the Zulu throne. I contacted Prince Makadi in order to verify if the rumors were true. I did so in order to deal with the matter at the royal family meeting of 14 May. Prince Makadi made it clear to me that the rumors were false and that he had no ambitions to become the heir to the Zulu throne. In order to make this clear, I requested him to record his position in a letter for me to convey to the members of the royal family and the world at large. On 11 May, Prince Makadi penned the letter and requested me to publish same to the media. The letter is attached here too. In that letter, Prince Simakade expressly disavowed any claim to the throne. Now, compare that with the actual content of the letter. That is where all of the misconception has arrived, and it illustrates the prejudice of that unsigned affidavit. This unsigned affidavit has been brought into these proceedings to give the wrong impression that that press statement, effectively, of the 11th of May is something in connection with the letter of 14th of May. There is nothing in the letter of the 11th of May that says, I disavow the position. There is nothing in the letter that says there's a meeting of the 14th of May coming up. There is nothing in the letter that says, please read out this letter to tell people that I disavow any claim to the throne.
But it says I can confirm that I have not told anyone that I accepted this position.
Sorry,
I can confirm that I have not told anyone that I accepted this position.
Yes. Yes, he doesn't covet the position. He doesn't covet the position. He's been told. That's what his elders have told him. You mustn't covet a position. You must sit, you must wait, you must see what the elders decide, and when they decide, we respect their decision. So saying I don't covet the position, he's saying I don't have o'erleaping ambition, I think, to use the words from Macbeth.
Desire.
I don't have o'erleaping ambition. I'm a disciplined member of this community. And I wait for the elders to tell me what to do. And it's got I do not covet this position, has to be read with the part that says, if I had been nominated, I would have taken the position. How can you take that letter and read it out at a meeting to say he has disavowed any claim to the throne? And what's happened is this unsigned affidavit has infused these very proceedings here in the Supreme Court of Appeal.
Sorry, Mr. Dodson, but at least that unsigned affidavit did not find its way in the Pietermaritzburg court proceedings before Madondo AJP. You see, Madondo AJP does refer to this letter, but this affidavit, unsigned affidavit of Prince Mangosuthu, it's an unsigned affidavit for the purposes of Pretoria High Court proceedings.
Yes.
So, in other words, the point I'm trying to make is that we do not have the record of the proceedings in the Pietermaritzburg High Court, other than the judgment of Madondo AJP. But Madondo AJP at 109 does make a reference to this letter by Prince Simakade.
Completely impermissibly, with respect.
Well, I don't know how it found its way into the court record, or was it annexed to an affidavit, but I assume that Prince Mangosuthu Buthelezi might have signed an affidavit, or he might have submitted this letter before Madondo AJ by way of an affidavit.
Indeed,
Yes.
but the position, and it's part of my subsequent argument that I'm coming to, is if you look at what took place there, very important to respect the silos in terms of the evidence. Two applications are brought. One to determine the consequences of a civil marriage, being his first marriage, the other to challenge the validity of the will. I don't know when exactly they began. We can work it out from the notices of motion. But those are two bits of litigation that are underway in the first half of 2021. The Prince Mbonisi application is brought when there's a rumor of a coronation in November 2021. That, we've got the papers, we've got the founding affidavit, and we've got the answering affidavit from that application. So we do have those pleadings. We don't have the pleadings from the other cases, as Deputy President, you've absolutely correctly pointed out. And the question I asked, just to pause there, is how on earth do we fairly, to Prince Simakade, adjudicate the question of res judicata when we don't even have the pleadings from those two cases? They cannot be used against him in any way. So if Judge Madondo has taken averments in affidavits that we don't have from those first two cases and transported them into Prince Mbonisi's application to proceed on his decision to settle the succession dispute, there cannot be raised judicata because there isn't a pleaded basis for him to have done so. And we know there isn't, because if we look at the founding and answering affidavits, there is not a mention of the 14th of May. Prince Simakadi's name appears nowhere in those founding and answering affidavits. And I'll give the reference.
But doesn't issue estoppel apply to the meeting of the 14th, the identification process?
Not at all. We don't know where that evidence comes from. We can't even see the affidavit.
But that's what a court has determined. A court has determined the outcome of the 14th of May. Are we entitled to determine it again?
Absolutely. If it was not a pleaded issue in dispute in that case.
No, but it was an issue. We know that the identification.
It wasn't an issue.
Because Madondo tells us
it was not.
One of the issues.
We can tell 100% that it wasn't an issue in the case because we have the founding and answering affidavits. That must be determinative. And if the court decides something that is not an issue pleaded between the parties, it was on a frolic. This court can't be bound by a frolic of a judge who decides something on the basis of evidence that isn't before him.
But at least in respect of two applications, Madondo AJP does identify the nomination as one of the issues that were before him, at least in two applications.
In the first two applications, and if you look at how he deals with those first two applications, in the Mbonisi application, he says those cases do not raise the succession dispute. He says it expressly. I think it's paragraphs somewhere around about paragraph 83, 84, 85. He specifically says the issues there did not involve the succession dispute. So that's his assessment. That's his assessment, and we must be bound by that. And the cause of action for seeking an interim interdict was those two applications. Pending those two applications, Prince Mbonisi said there should be interim relief that prevents appointments and all that kind of thing. Mm. But it was linked in with those two applications. Madondo points that out.
But let's look at page 153.
15?
Page 153 of volume 1. These are the issues that are being identified by Justice Madondo under case number 10879. And one of the issues relates to paragraph C. King Misuzulu was legitimately and appropriately identified and nominated as the successor of the late.
Yes. He's written it in the judgment, but we've got for ourselves the pleadings, and it doesn't raise the issue. Also important in this context to remember is there was no consolidation between the first two applications and the Prince Mbonisi application. That's contained in paragraph 1, the very opening paragraph of the judgment. He says, makes it clear, initially it is a bit unclear, suggests it might be joined to water, and then he makes it clear. He says, I joined those two, and then I directed that the third application be heard together with this application. The other important thing, Justice Bachane, is that if you look at his reasoning in the judgment, there are 2 points, there are 2 exit points, if I can call them that, where he has already been through a reasoning process to be able to arrive at the relief that he grants, which is to dismiss this application. The first one of those, if the court will just bear with me, is paragraph 80. He says the date of 3 December, that's when this coronation was meant to take place, has come and gone without the alleged coronation taking place, notwithstanding the fact that this court declined to grant the urgent relief sought on 2 December 2021. As a consequence, it is now common cause between the parties that there is no coronation implicating public funds underway. The application has in fact become moot and irrelevant. So anything that he says after that point is arbiter.
But in any event, Mr. Dawson, the judgment of Madondo AJP is not before us on appeal.
Indeed.
Well, that's it.
Indeed, but
its analysis, is it going to assist us?
this court is entitled to look behind and look what went
Well,
on.
there are no pleadings. I mean, we could do that if we've got a complete set of pleadings that serve before Madondo AJP and the judgment, and then we can say, okay. But only if it is properly before us.
But we have the pleadings, Deputy President. We have the pleadings before us. And I can take the court to them if the court will bear with me.
The pleadings in relation to all three applications?
No. But the pleadings, but importantly, the pleadings in respect of the case where res judicata is pleaded, the only case in which res judicata has been and can be pleaded is in the Prince Mbonisi application. Nowhere else. That's even on Judge Madondo's version, because he said that the leadership dispute does not arise in the other two cases. So even if we found the pleadings there, and they said something about it, it's clear, and it's clear also on what the central focus of those cases was. They're not decided there. So we are front and center, and the only place we are in is in the Mbonisi application. And there we have the founding affidavit and the answering affidavit. Let's go through them. They do not deal with this issue. And this court is entitled to look at the pleadings to see whether the judgment fairly reflects the pleadings. Just before I move off there, and while we're still busy with the judgment, if I can just complete the other submission that I was making in response to Justice Patswane, which is the other exit point that rendered it moot. And if the court will just bear with me to go back there. The other exit point is at paragraph 84 on page 156. It says, the applicant prints furthermore, this is at the bottom of paragraph 84, the applicant prints furthermore does not state whom he represents. Applicant Prince has approached this court on misinformation and incorrect facts. He eventually submitted that there is no official coronation of Prince Misuzulu utilizing public funds underway. Consequently, the applicant has not made out a case for the relief sought in the notice of motion. Boom. That's the end of the case. Anything that comes after that is his musing. It's his musing. We all know. Justice Madondo, he's written a book on customary law. He's interested in this stuff. It's a helpful little book that he's written on customary law. It's his interest that he's pursuing, and he should not have pursued. This court has said repeatedly in recent times that a judge must stick to the pleaded issues between the parties and may not go beyond them. Now, if it's clear on the pleadings that he has done that, this court cannot be held bound from a res judicata point of view by that judgment. If one looks, for example, at the D'Souza judgment of Justice Wallace, he looks. So there the case was whether a decision of the CCMA effectively determined an aspect of the litigation in front of him. He looks at the pleadings very carefully. He goes back and analyzes and looks at what the transcript actually said of the evidence. He looks at that to see whether it should in fact be binding. And this court of all courts, sitting in the hierarchy where it does, with respect, cannot say, we're not going to look at the pleadings. In fact, if there's
Can I just get this quite clear? So after 84, you say the rest of the judgment, after paragraph 84, the rest of the judgment are basically his musings on customary law.
It's arbiter.
And we should
put a pen, for purposes of res judicata, put a pen through.
After 84.
Indeed. And it's reinforced by the fact that he says, anybody who wants to review, if you'd come to my court, I would have chucked you out on the basis that you were here prematurely. that confirms that this is arbiter. And arbiter, what's interesting in the Mkhize judgment that my learned friend referred to is the link that's drawn between precedent and res judicata, how they operate in tandem. Well, what does that tell us? It tells us that if something is arbiter, it can't be binding for the purposes of a plea of res judicata. The other point that we make is this: if there is a shortage of evidence to show what went on in that case and to show the pleadings, that shouldn't be something laid at the door of Prince Simakade. It should be laid at the door of the party raising res judicata. A responsible raising of res judicata in this case required Prince Misuzulu, with his answering affidavit, to raise it, to gather all the pleadings, any evidence that was led, all the affidavits, and attach them to and explain them in his answering affidavit. It did not happen in this case. They ask us to look at heads of argument that were found, heads of argument on pleadings. They can terribly misrepresent what the case was all about. The other important point to bear in mind is that, and in fact it's not adequately acknowledged in the judgments on res judicata, is we are talking about Section 34 of the Constitution. The application of res judicata to exclude a litigant is a limitation of the litigant's rights in terms of Section 34 of the Constitution. And for that reason, the courts need to approach it very, very carefully. It's acknowledged even in some of the earlier judgments that a tremendous injustice can be done by a plea of res judicata. Long before we had a constitution, we now have Section 34 that guarantees the right to be heard in front of a tribunal. This case is unique because it's not just Section 34. It's Section 34 and it is Section 33.3. What the appellants in this case asked this court to do is extraordinary. They say, because of an arbiter judgment of Justice Madondo, Prince Simakade must be denied both his constitutional right to review administrative action and his right to have a hearing before a court of law in terms of Section 34. That is unprecedented. And if one looks also again at the Mkhize judgment that my learned friend referred to, the Mkhize judgment, you'll recall, it involved an extraordinary flurry of litigation. I had great sympathy for Justice George because it must have been a pile of paper this high. There were applications, counter-applications, interlocutories. The list was endless. But through all of that, what the Constitutional Court does is it jealously guards Mrs. Mkhize's right to judicial review. Very carefully. You'll recall that she was trying to pick up, because her husband had litigation related to traditional leadership issues. He'd been appointed and his appointment had been withdrawn. He died before his litigation, his review had been resolved. And the Constitutional Court was at pains, as far as possible, to protect her right to take over that review. They said to her, okay, you can't pursue your review insofar as it asks for you to be, insofar as he was asking to be reinstated in his position as traditional leader. But what you can do is pursue it in all other respects, to protect your son's claim, to protect the monetary claim from the salary that he should have got, which you would inherit. The court is, and the court comments on the fact that about the importance of a right of review. The Ota judgment of the Constitutional Court as well makes the point that one must be very careful in interlocutory litigation about usurping what the reviewing court needs to do. Yes, it was speaking in an appellate context, but I submit it's of equal application throughout the court process. Be careful where somebody has a constitutional right of review that you don't, through a ruling in an interlocutory, deprive somebody of their rights. And that is exactly what the appellants are asking this court to do, to sanction a deprival of Prince Simakade's right to review that decision. Another component of it, Prince Simakade, before the president has even taken his decision under 8.4, says openly, there's no basis for you to exercise your powers under Section 84. How on earth can a judge with the greatest of respect to Justice Madondo do that? It is a preeminent breach of the separation of powers. It's a preemptive strike on the president. And the president should have treated it as a serious incursion of the separation of powers. How could he do that? And this court, with respect, that automatically renders it arbiter. You make a ruling on an event that has yet to take place. How on earth can that have any binding effect? It cannot have any binding effect. It has to be the most arbiter of arbiters if one is to do that. Yet that is what our learned friends ask us to do in these proceedings. The other important aspect in relation to this litigation, let's assume that Prince Simakade was served in relation to this litigation. With the greatest of respect, why on God's earth would he get involved? If he's got a pending potential review, why on God's earth would he get involved in, with all due respect to Prince Mbonise, an extremely ill-advised interim intellect application?
Are you referring now to the High Court proceedings in Pretoria?
The High Court's?
Proceedings in Pretoria.
No. I beg your pardon. No, I'm talking about the proceedings in front of Justice Madondo.
Okay.
I'm talking about the proceedings, I beg your pardon, Deputy President. The rhetorical question I ask is, why on earth would Prince Simakade, if he had been served, get involved in those proceedings in Pietermaritzburg, which are being brought on the basis of rumors? How can you bring an urgent application on the basis of a rumor? And what everybody's saying is, yeah, you should have joined that application. Why? You could see from 1,000 miles away the application was going to be dismissed. Nowhere in the founding affidavit, and I know I've promised to come to them, is his name even mentioned. Nowhere in the answering affidavit is his name even mentioned. Why on earth would he get involved in in a fool's errand? There was no reason for him to do so, and to deprive him now on that basis of his right of review would be completely contrary to what the courts have warned against with res judicata, that you can inflict terrible injustice on people by doing that.
But did he not get involved by virtue of his confirmatory affidavit?
No. His confirmatory affidavit pertains to the second application.
Oh.
And in fact, it's a helpful kind of pointer, because if I remember correctly, I think he signed it or stamped on the 25th of May 2021. And Prince Mbonise only starts his application in November 2021. The very interesting thing about the joinder issue is that one of the reasons in that last extract that I read, where I say was the second exit point after which it became arbiter, one of his complaints is the non-joinder of the two princesses who brought the will application. Now, if you look at this document that's been circulated this morning in the application brought by my learned friend for the president, their two names appear in that same Annexure A that Prince Simakade does. Yet, Justice Madondo says in that same paragraph, I'm dismissing this application because he failed to join the members of the royal family. So as far as Justice Madondo was concerned, it didn't satisfy service if you were already in those other two applications. He clearly wanted fresh service. And it also didn't help if you stuck Annexure A to your notice of motion and included names there, including those two princesses, and said, thereby, you're somehow served. I am confident that there was no proper service in respect to that. I may well be proven wrong. But what we did for this application is we served properly on the royal family. We arranged for the deputy sheriff to go to every single palace. We arranged for publication in the press. all of these steps set out in order to ensure that there was proper service. I seriously doubt whether those steps can be seen there in the part of the record. I seriously doubt that took place in relation to this. But I may yet be proven wrong.
I must just warn you about your 2 hours that was allocated to you. But yeah, you may proceed. Just to make sure that you have almost exhausted your 2 hours.
Does my head get chopped off at 1 o'clock?
No, we can proceed until 1 o'clock.
As the court, please, if the court will just bear with me.
Just to make sure that if you still have some more submissions to make, then you...
Deputy President, would it be possible for us to take the lunch adjournment now? I can do a quick audit during the lunch break to see what I have or haven't covered, and I have 10 minutes when we restart.
Do you have anything to say now or before we adjourn?
No. If we could just have those 10 minutes when we come back, that would be greatly appreciated. We certainly need to say something about relief.
Your submissions have covered your cross appeal. You remember you've got a cross appeal.
I think they have.
Just make sure that
yes,
you have covered.
Yes, I've got submissions to make in relief, just to make sure that we're clear with the court as to what it is that we're seeking and explain it. But I think I have covered our cross appeal substantially.
Okay, then you'll wrap up when we return.
Indeed,
lunch.
Deputy President.
The court adjourns until 2 o'clock. Thank you.
Yeah, that's what I was thinking.
Yes, Mr. Dodson.
As the court pleases, Deputy President. Deputy President, in my conclusion, I'm mostly going to just give references to clarify certain issues with some brief submissions before I deal with relief. Justice Pachwane asked about the methodology of the mediation panel in relation to how they gathered their evidence. If I can just give a reference for that. It's at volume 8. Page 1527. 1257, my dyslexic kicked in. 1257 and following. The pleadings for the Imbonisi application are the founding affidavit at page 1970 in volume 10. There, if I could just perhaps ask the court to quickly refer to that. So, volume 10, page 1970. If I could ask the court to go to volume 10, page 1970. That's the start of the application. I just want to have a quick look.
Just give me a sec.
I beg your pardon, Deputy.
Got it, yeah.
There's volume 10. It starts, just to give the pages for the founding affidavit, it's 1970 to 1989. 1970 to 1989, but there's a particular page I'd respectfully ask the court to go to, which is 1987. And that's paragraph 12.2 at 1987, where they deal with the prima facie right. So this is the underlying cause of action that they're motivating the interdict on the basis of. He says, I have a right and interest in the affairs of the royal family, in particular the outcome of the pending consolidated applications. So that's a reference to the will and the civil marriage application. 12.2.2, I have a right of access to court and to have any dispute resolved through the application of law in a fair public hearing in court. 12.2.3, I assert that as a member of the royal family, I have a right to insist that there must be compliance with the law and the Zulu customs and its practices. 12.2.4, accordingly I submit that I've made out a case showing the nature of the right I want to protect. No reference in the part where it should be housed to finally resolving the traditional leadership dispute. We can then look at the answering affidavit. The answering affidavit is at page 1990 to 2002. And if I could just ask the court to please have a look at paragraph 10 quickly on page 1993. 1993. And one sees there Chief Buthelezi summarizing the issues as far as the Imbonisi application is concerned. Firstly, the applicant has no longer stand-out to bring these proceedings. That's 10.1. 10.2. Secondly, there is a material non-joinder of necessary parties, in particular the African Queen and the case that Queen Sibongile Winifred Zulu. That gets expanded on later in the affidavit where he refers to the entire royal family. Thirdly, the matter is alibi lis pendens and is yet to be determined by this court in fewer than 5 days from the time this urgent matter has been set down. Fourthly, the matter is not urgent and no grounds for urgency have been established. Finally, the application is misguided and the applicant has no right prima facie otherwise to the relief he seeks. The official coronation is envisaged in terms of Section 17.5 of the KwaZulu-Natal Governance Act is not imminent. So again, no reference to deciding anything in relation to Prince Simakade or an overall resolution of the traditional leadership dispute. I also mentioned that Mbonisi in fact supported Prince Simakade on Ukupakwa, and just to give the reference there, I do not ask the court to go there. It's volume 18, page 3525, at paragraph 104 and following. Covers about 2 pages. Then briefly, a point not covered, I don't think, in our heads of argument, is that the President was requested by Prince Simakade's attorneys in writing in terms of Section 5.1 of Padja to provide reasons for his recognition decision. And the reference there, no need to go to it, is founding affidavit, paragraph 8, volume 14, page 2689. Those reasons were not provided. And as a result of that, Section 5, subsection 3 of Padja kicked in. And it reads, if an administrator fails to furnish adequate reasons for an administrative action, it must, subject to subsection 4, and in the absence of proof to the contrary, be presumed in any proceedings for judicial review that the administrative action was taken without good reason. So the onus is on the President in this case to show that he acted with good reason. And then before dealing with the relief, 2 points. The one is we simply make this point that there have been intensive debates in the course of the hearing about issues like Ukufakwa, like the interpretation of the letter of the 11th of May, and so on. Those types of issues we submit are not issues that this court has to resolve, including the 14th of May meeting. As long as there's evidence or an allegation that's contemplated in Section 8.4, that is the issue. That is the determinative decision. And no final decision we would submit is required in respect of those debates. Then an issue that is the implications of which have not been become clear to us yet is that in the Mogale judgment, which declared the Traditional and Khoisan Leadership Act invalid, they suspended the declaration of invalidity for 2 years. That order was made on the 30th of May 2 years ago. So on our estimation, unless the Constitutional Court extends the order of suspension of its order of, suspends its order of invalidity by, we think, midnight tonight, the entire act may become invalid. We have somebody who is involved in that litigation who's reporting to us. They say they still haven't heard from the Constitutional Court. There is an application pending before the Constitutional Court to extend it so that it would remain in place. It's apparently supported by all of the parties and is unopposed, but they do not yet have an answer from the Constitutional Court. But if it lapses, I think it will be necessary for the parties to make written submissions on what the implications of that lapsing would be. And we will keep checking and inform the court if we hear anything. Then, in terms of the relief that we seek, we ask that the President and Prince Misuzulu's appeals be dismissed, with the President to pay Prince Simakade's costs. Such costs to include the costs of 3 counsel where employed, and further to include the costs of resisting their applications for leave to appeal. Prince Simakade asks that his cross appeal be upheld with costs. Such costs to include the costs of 3 counsel where employed, and to further to include the costs of the application for leave to cross appeal. We ask that the President pays the costs on the basis that this is constitutional litigation and BioWatch therefore applies. There is Constitutional Court authority directly in point in the Impepho judgment of the Constitutional Court at paragraphs 81 to 83, and there in a similar contest over a leadership position where in fact the President and the Minister abided the decision of the court, so they didn't even participate and oppose or side with any party, they were still required to pay the successful party's costs. So we say we're entitled, in the event of success, to recover costs from the President. We, on the basis of a judgment of this court, it's a majority judgment which was penned by Justice Nichols, if I remember correctly, in South Durban Environmental Alliance, which deals with the costs as between private parties in this type of litigation. And our understanding of that judgment in this case would be that if we were unsuccessful, each of the private parties, as it were, should bear their own costs, unless they've litigated irresponsibly. We adopt the attitude that even if we're successful, we only seek costs against the President. We don't seek costs against Prince Misuzulu. One way or another, whatever the outcome, the two are going to have to live together, and we don't think it's going to be helpful to make cost orders. And it's obviously implicit in that we oppose their request for a cost order against Prince Makadi in the event that they are successful. We support paragraph 1 and 3 of the High Court's order. We say that they were correctly decided. Our only gripe with paragraph 2 is insofar as we asked the court to include the word afresh after the word investigation. So we asked them to say investigation afresh. And the purpose of that was to make sure that the President and the investigation panel didn't consider themselves bound by the judgment of Judge Madondo. And the court did not grant our request. It was contained in a draft order that was handed up and debated in court. And we have included that in we've applied for leave to appeal on that basis and included it in our draft order. And that draft order is to be found at page 4919 of the supplementary bundle. And we there in paragraphs 2.1 to 2.4 have set out what we respectfully submit would be an appropriate order to substitute the order of the High Court. It incorporates the paragraphs that we support, that we defend, but it also adds the word afresh after the word investigation in paragraph 2.3, and it also includes the directions that I explained in argument to ensure that there was an accountable participatory process in relation to the investigating committee. Although we didn't ask for it, it would be within this court's jurisdiction, based on Motorclip and other cases, to also say in this court's order, in the event that we were successful, that the plea of res judicata is dismissed. But the inclusion of the word afresh, I think, would have the same consequence. Those are the submissions. Those are the submissions on behalf of Prince Makadi. Just one remaining aspect, and I have to apologize sincerely to the court in this regard. Our hearing is not great. I'd really struggled to hear from where I was sitting what the dimensions of the application were in relation to the service and the document that was handed up. As I understood it, the President must justify the document that they seek to hand up. and they must do so with an affidavit, and we must answer that. If it's as narrow as that, we don't see a particular difficulty with responding in time if it's essentially legal points that are made in the affidavit. But if it involves us having to consult with Prince Simakade, we have a little bit of a logistical difficulty in that we have an attorney who is in Trichard, counsel who are spread between Johannesburg and Durban, and Prince Simakade who's in northern KwaZulu-Natal. And I think we would need a little bit more than a day to be able to file an answering affidavit. So it depends really on the ambit of the application that the court envisages.
I just want to go to my notes on the directives in this regard. What did I say? They were going to file that affidavit on Monday, by Monday, and then as we directed Prince Simakade to file by Tuesday. So are you saying that you might have a problem?
It might be logistically difficult for us to file within 24 hours, Deputy President.
Let me just go back. So
perhaps if we could have 3 days,
which will be Wednesday or Thursday.
Mr. Dodson, while we're working that out, what page reference did you give for the order that you seek?
It's in the supplementary volume, and it starts at the substitutionary order starts at page 4919.
Okay.
Is the court
And
please?
that, so yeah. All right. Thank you.
As the court please. Thank you.
Yes. Anything in reply, Mr. Moran?
Yes. Deputy President, the reply.
Before you say anything, then are you happy with the arrangement now, in terms of which Prince Simakade will have to file an answering affidavit by Thursday next week?
Deputy President, today is Thursday afternoon, and we are supposed to file by Monday as an intervening weekend. Maybe we might need a bit more time than this.
Okay. Let us reinvent the wheel now. Let us reinvent the wheel. Okay, how much time do you need?
By Wednesday, I think that will be more realistic.
So, okay. So, which means that Prince Simakade will have to respond by Monday. And then, but if there's any reply, if it's necessary, that will be done on Tuesday. what the reply is.
Yeah, as the court pleases. I really don't expect this to be something contested. It's a very, very narrow issue, just handing in what should really be common cause, adopting this attitude adopted by Prince Mbonisi's representative. It shouldn't be a complex thing.
Yeah, I know.
Just putting a few facts.
I don't know, Mr. White, do you want to say anything regarding the timelines that have now shifted?
No, Deputy President. I think we can do it on Monday from our side. We already have put the wood on the fire already, so
okay.
It's still realistic for us.
All right. Mr. Masuku, do you want to say anything?
It's a concern dealing with when Mr. Moran said a few facts, so I'm not sure anymore what. It was simply to place the affidavit before the court. I'm not sure whether there are any facts more than just that.
Okay.
In which case we don't really take a position.
Thank you. All right. Anything in the well? Let's proceed, Mr. Morana. You may take the podium. Anything in reply?
Yes. The reply will be done by my colleague Muvangwa.
Thank you. Thank you, Ms.
Pleases the court.
Right.
Deputy President, I would like to start the reply on the last issue that my learned friend, Mr. Dodson, dealt with, which is Justice Madondo's judgment and the status thereof. At the outset, I must say that my learned friend, Mr. Dodson, invites this court into very dangerous waters, and the court must decline the invitation. My learned friend, Mr. Dodson, suggests to this court that it may very well be possible to undo Justice Madondo's judgment. It was spoken here about pleadings before the judgment, or the court rather, and what the judge ought to and ought not to have taken into consideration in light of the pleadings. The submission, Justices, is that the judgment by Justice Madondo speaks for itself. It is not open to this court to untangle or mess with it at all, with respect. It was never appealed against, and inviting this court to fiddle with it would amount to a backdoor appeal, or at worst, a review, which is not a thing in our law. If the court would indulge me, I would like to take this court, especially to the parts of the judgment that relate to Prince Bonisi's application before that court. The court will recall that the judgment starts at page, I believe, 150, of 120 rather, of volume 1. I'm obviously in a hurry to get to 150. But 150 is where the judgment pertaining to Prince Bonisi begins. Now, I'd like to draw the court's attention specifically to page 151, paragraph 68. There, Justice Madondo recast the order that Prince Bonisi sought before him. 68B says, interdicting and restraining the fourth respondent would have been the President. Interdicting the fourth respondent from recognizing or undertaking any steps which may reasonably be construed as recognizing the first respondent, that's King Misuzulu, as Isilo SAMaZulu, pending the final determination of the applications under the 2 case numbers listed there. The court will also recall, because much interaction was had with this, that the princess's applications had to do with the wills. All right. Now, if the court would please turn to page 153. In light of the relief sought by Prince Mbonisi, the court, as it was entitled to do, posits questions, issues, really issues are questions that the court ought to answer in order to determine whether a litigant is entitled to the relief that they seek or not. The court does that in paragraph 78. There is an interdict sought against the recognition of King Misuzulu as Isilo SAMaZulu. So the court says, well, in order for me to answer that, to determine that, I need to ask the following question. C, 78C says, was one of the issues. Prince Misuzulu was legitimately and appropriately identified and nominated as a successor to the late Isilo. So that's a question that Justice Madondo posits for himself to answer. Now, in the course of answering that, the court determines that King Misuzulu was legitimately identified. And the basis of that, on the basis of that rather, the court dismissed the interdict sought. I would like to draw the court's attention to paragraph 98 of that judgment. So remember, the submission, on the basis of that, it's not even a submission, it's a fact. I'm looking at the judgment with the court. So one of the issues is the legitimacy of identifying King Misuzulu, okay? On the basis of that, the court dismisses the interdict, which said, do not recognize until something else happens. In paragraph 98, the bit I'm interested in is at page 163. In the middle of the paragraph, the court says, the inevitable conclusion is that even if the late Isilo's will is found to be invalid, you recall that this is the case about the will brought by the princesses. Even if that is found to be invalid, it would not have any bearing on the succession of the to the Zulu throne, I beg your pardon. In addition, the royal family, which in terms of the Leadership Act and customary law, has the prerogative to appoint traditional leadership, assembled on 14 May 2021 and identified Prince Misuzulu as the successor to the late Isilo. Now, I have read out just one paragraph of many where Justice Madondo deals extensively with the status of the meeting of 14 May. So that's the moment where the court does not delegitimize. It was not obiter. It was considered in the course of answering an issue before the court, an issue that was given rise to by an order sought in those proceedings. So what is the point I am making? The point I am making is twofold. The one is that any suggestion whatsoever that it is open to this court to go behind a judgment that speaks for itself, to interrogate the pleadings before that court in order to determine whether or not that judgment is res judicata, is dangerous, and it just cannot be. It is inconsistent with the principle of res judicata. So that's the first point in reply.
Can I just ask you, Mr. Dodson seemed to say that the res judicata principle would be in contravention of his constitutional rights of, I think, section 34 and 33.3, judicial review and access to courts. What do you say about that?
Yes, I've got an answer to that, and thank you for the question. My answer is multifaceted. If confined to these facts, Well, so the first thing is, if Mr. Dodson is suggesting that res judicata is anemic to constitutional rights, that's a different debate that is not pleaded before this court. As I understand the position, it is that if this court were to confirm the High Court's decision that Justice Madondo's judgment is res judicata, then that would contravene his client's constitutional rights. Now, the law is also settled that the principles, there must be finality. An issue estoppel that my learned friend, Mr. Nkaitobi, spoke at length about, brings about exactly the kind of finality that the law requires. However, the law does make provision to relax the principle of res judicata if there is no alternative remedy. President, in his heads of argument, says that it was never foreclosed to Prince Simakade to seek intervention and seek to rescind Justice Madondo's judgment. That is an alternative remedy available. We are not told, I don't know, you don't know because you were not told why that wasn't done. It still hasn't happened. So that's the answer. The next point I would like to move on to.
Sorry, but isn't the point that within the context where a relief of an interim nature is sought, it will violate the right to access to a litigant if res judicata is raised within the context where the relief is like within the context of an interdictory application where an interim relief is sought. Now you apply res judicata principle in those circumstances. Doesn't that violate the right to access to court in terms of Section 34 of the Constitution?
Justice Zondi, I'd like to go back to a paragraph that my learned friend, I can't recall if it was Mr. Masuku or Mr. Dodson, referred this court to, because where this was coming from was a paragraph, I think it was 102, as well as 91, where Justice Madondo says that, I don't need to go there, I remember what it said. It said that one cannot review, it would be premature effectively, to review the recognition decision yet, because the president had not made that decision. Now, nobody's right of access to court is foreclosed because no one tells this court, first of all, Justice Madondo did not recognize anybody. He confirmed the legitimacy of an identification process. He made findings that were conclusive there. It was open to any litigant to appeal against that judgment on the narrow scope of the legitimization of the identification. That didn't happen. So no one's right of access to court is foreclosed if the principle of res judicata is confirmed. The second thing is there is inherent in our law a principle that permits the relaxation of the principle. And that is the moment where there is no alternative remedy. Well, there is here. And I think that must be balanced against the need for finality, really. Because otherwise, we're going to run around in circles where people are trying to forever undo decisions of courts that are final. Now, the next thing I want to talk about is this idea of the 11 May letter. I must confess, I do not speak any isiZulu. I don't purport to read it. I relied on the translation. But be that as it may, what I would like to say to this court, and hopefully my learned friend, Mr. Nkaitobi, would unpack it because he understands isiZulu, is Justice Madondo found that paragraph 98, in fact, I don't need to take the quote there because I am mindful of time, found that Prince Simakade, whether it is disassociate, disavow, anything, that was a finding by a court and that was never challenged. Yeah, that's paragraph 98. I think it's fine. So that's the quick point I wanted to make on that score. The next point I want to talk about is Princess Thembi's letter. My learned friend, Mr. Masuku, says that the president himself did not see Princess Thembi's allegations or contentions, whatever it is in the letter, as frivolous, and referred this to a panel for consideration through the minister and so on. He then said that the report from the panel included an option for further investigation and so on, but what he doesn't say is that the panel also included in a recommendation that everybody waits until the findings of a court, then move forward. This the court will find in volume 3. The report is at page 529. The recommendation that I'm talking about is set out in paragraph 7 at page 569. 7.1 is one of the options. The idea that there must be further investigations was not the only recommendation. It was one of others. One of those was quite literally that the minister and the president are advised to wait for Justice Madondo to make decisions. And that is the route that the president elected to follow. Now, there is actually nothing in these papers that suggests to anybody that the president's attitude was that this was not frivolous. That's not there. He simply waited for the court to make a determination, and then he did what he needed to do in terms of the TECLA Act. Now, it was also argued somehow that Justice Madondo foreclosed the president from exercising his powers under Section 8.4. That's not the president's version. The president's version is that he stood guided by a judicial determination and the status of Princess Thembi's letter before he moved. That's all he says. I was guided by Justice Madondo. My learned colleague, Mr. Moirane, took the court through the relevant paragraph. It's a paragraph 101 of Justice Madondo's judgment yesterday, where Justice Madondo conclusively assesses and determines on the standard of Princess Thembi Ndlovu's letter. And that is what guided my client. The next thing I want to talk about is that the president was somehow compelled to act in terms of Section 8.4. I don't wish to repeat myself, but the president's position is clear. He relied on Justice Madondo's findings, and Justice Madondo's judgment was and remains in force and binding until set aside. I believe that vote has probably come and gone, and that judgment was never set aside. So that remained of force and effect. Next point I want to talk about is res judicata. I actually have spoken about this. Was this contention by my learned friend, Mr. Masuku, that in fact Justice Madondo's judgment is not res judicata, he said, because he left the door open. He actually made direct reference to paragraph 102 of the judgment, where Justice Madondo says that effectively that it would be premature to review the recognition decision, and he then says the Premier or the President as an organ of state has not acted yet, and otherwise would be, if it were to be sought, it would be dismissed. Had the applicant sought to review the identification, their application would equally have been dismissed, solely on the ground that it was premature. That's not leaving a door open at all to counter this submission that Justice Madondo's judgment is res judicata. He's talking about reviews of decisions to recognize. He says the decision to recognize commences with an identification. So if you review an identification, it would be incoherent, is literally what he says. He does not say it's not open to you to appeal. Does not say. In fact, there was an attempt at an appeal, which was never prosecuted. So that argument cannot hold either. The next point I wish to make concerns the legitimacy of the 14 May 2021 meeting. The submission, as I understood it, was in part that meeting was called by somebody who ought not to because he lacked authority. As far as it relates to my client, the subtext here is that the president ought to have queried the legitimacy of that meeting on the basis that it was called by Prince Buthelezi, who had no authority to do so. Justices of this court, I have now repeated myself so many times. The answer, as you would guess, is that Justice Madondo determinedly found that Prince Buthelezi was legitimate a person to call such a meeting. This you will find in paragraph 84, and he decided that point on the basis of Plascon Evans. And, you know, it's kind of a very dangerous invitation a suggestion to make. This notion that the executive can go behind a judicial determination and do something else. That cannot be.
Well, Mr. Dodson also says that everything from 85 onwards is obiter, and we must just put a pen to it.
But I mean, Justice Nichols, I just demonstrated with relation to paragraph 98, for example, that what the court says in paragraph 98 had a direct bearing on a question before it. That surely couldn't be obiter. The last point I have to make is to my learned friend. I actually don't remember which ones of my learned friends. I think it was my learned friend, Mr. Masuku, said that on this consultation of the premier point, he said that the president consulted the premier through the minister, and that's not sufficient for purposes of section 8.1.
Sorry, Ms.
Mubango.
I'm not sure if you have given an answer to my colleague's question regarding what is stated in paragraph 84, the last line. The point being that whatever is said subsequent to what is stated in paragraph 84, we must just disregard it because it's an obiter. It's something that was necessary for the purposes of arriving at the...
I'm just going to 84 quickly.
Yes.
To make sure I don't run away.
Paragraph 84 of Madondo is 156.
I beg your pardon, Justice Zondi?
It's page 156.
Yes, I got it.
Yes, the last line where Madondo AJP conclude by saying, consequently, the applicant has not made out a case for the relief sought in the notice of motion.
No.
The proposition that is put to you is, was it necessary for him to go further after having concluded that the applicant had not made out a case? Was it necessary for him to say whatever he said subsequent to
yes.
paragraph 85?
You see, Justice Zondi,
yes.
Judgments can have different bases for a finding. This, in my submission, is one of the findings. What he then does, for example, in paragraph 98 that I took the court to, is not obiter. Because he says nothing turns on the wheels for present purposes to determine whether or not King Misuzulu was legitimately identified.
Okay.
So that's not obiter at all, because that informs the question of the legitimacy of the identification, of legitimacy of King Misuzulu's identification.
All right, thank you.
I'm told okay, I'm invited to refer this court to a decision, and I will, because I don't want to not do that. The court's decision is, this court in fact, is Hibiscus Municipality, Hibiscus, versus Hume Housing. It's SCA 638/15, and it's unreported. And the court confirmed this decision, this submission that I just made.
What is the ZASCA number under here? That's what we require
just
in this court.
I'll provide this. I'll do that now, not just write it down on a piece of paper. It's easy. Okay, my very learned friend for Prince Makade has given it to me. It is ZAXA 71. It's a 2016. The date is 23 May 2016. And the paragraph in reference is paragraph 16. Where a court furnishes more than one basis for its determination of an issue, each such basis being dispositive, the second and further basis remain ratio. Thank you. And do not become obiter. Or let me just read the whole thing. Where a court furnishes more than one basis for its determination of an issue, each such basis is being dispositive, the second and further basis remain ratio decidendi and do not become obiter dictum merely because the first basis is dispositive of the case. This is from this court. All right, so the last point I was making was this idea that consulting the Premier through the Minister is not enough. My learned friend did not tell me why that was not enough, neither did he tell the court, but this court in the Reineke case, citation is 2014, SA 205, postulated a test for after consultation with in paragraph 9, and that test is simple. You must demonstrate that the decision maker was receptive to the views of, in this case, the Premier and the Minister. So in other words, all it has to be demonstrated is that the decision maker was receptive to their views. Doesn't say you have to agree with them. So that's the first thing. The second thing is there is nothing in section 81B of the Tekla Act that prescribes the manner in which the President ought to have consulted with the Minister and the Premier. He chose to go this route, and it was not suggested before this court at all that he was not receptive to their views. So
but 81B says the President may offer consultation with the Minister and the Premier concerned.
Yes.
Are you saying he did consult with the Premier?
He did. He did consult with the Premier because on 16, and I will give the court the reference, the submission is that he did consult with the Premier because on 16 August 2021, he wrote a letter to the Minister. This you will find in volume 3, page 524. He writes to the Premier, I beg your pardon, to the Minister. I think, yes, that's page 524.
Is it a letter where the president requested the minister to, in consultation
Yes,
with the provincial government?
yes,
Oh, okay,
that's it.
sure.
And a whole process follows after that. I can narrate briefly and give references. So after he does that, the minister goes and does as requested. And she does say, for example, on 18 February, same volume, letter at page 525. The letter, the minister writes to the president. Let's just go there quickly. Let me make a note of that. Yes, oh yes. So on that date, the minister submits to the report to the president the report of the panel. Now that panel was appointed together with the premier, and I'll tell the court why I say this. Because on 5 August, the premier wrote a letter to the minister, proposed people that could serve on a panel. In fact, the idea of a panel came from the premier. Then on 25 August, the minister appoints the panel. 2 of the people who ended up serving on that panel came from the list nominated by the premier. And the support provided to that panel was from the office of the premier as well as from the provincial office of the department. And every iteration, and I'll give the references in fact, let me do it now instead of promising too much. I refer also to the letter of the minister dated 16 March. It's volume 13, page 2562.
Is it a letter where the minister says she's in support of the recognition of King Misuzulu?
That's what she says, yes.
That's
Importantly, she does say in paragraph 8, Your Excellency requested the Copta minister to attend to this and I have done it. So the totality of the interaction and the objective evidence demonstrates that there was interaction between the minister and the premier, and together, something that he requested was placed before the president. Again, I must remind the court, there has been no suggestion made by my learned friends that the president was not receptive to the views of the premier and the minister. There is also nothing prescribed in the Act about the manner in which the president ought to go about consulting the premier and the minister. The test is reception. He had an open mind. So those are my submissions in reply.
Thank you, Ms. Mango.
I must give you the reference for the appointment of the panel. That you would find, and this is where it says where the support staff came from. That you will find in volume 7, page 1388. There are various appointment letters that follow there, but para 9 speaks specifically of the kind of support that I was talking about. Justice Zondi and members of the court, those are my submissions. I believe I've got 25 more minutes left, which I would like to do.
No, who told you that you had more than? No, we didn't allocate any time to you. Okay, thank you. Yes, Mr. Great.
Yes. Deputy President, I would like to start with what Mr. Dodson called curative, which in fact did not show anything but added confusion. Firstly, he protests about the affidavit of Mr. Buthelezi, Prince Buthelezi, which he says was filed in an application that they, as Prince Simakade, had nothing to do with. That is simply untrue. Let me show you why. If you go to volume 9, at 1753.
Okay, just give me a sec, I just want to get volume 9.
So if you go to volume 9 at 1753, that is an affidavit filed by my client, His Majesty, King Misuzulu, as a supplementary affidavit, in which he says, in this case, the case we're dealing with now, not another case, this case, in which he says at page 1756 that one of the things that he wants to do in paragraph 3.3 is to place before the Honorable Court certain evidence in answer to new evidence in both Prince Simakade, that is Mr. Stotz's client, and Prince Mbonisi's reply. Luckily, Mr. Masuku didn't make this problem. In the present application, and those are then identified as KM1, KM2. Then if you go to volume 10, you find this particular affidavit as KM11 at page 1895. But KM11...
Give me a sec, I just want to...
KM11 at 1895. KM11, however, is foreshadowed in King Misuzulu's affidavit at page 1761, paragraph 6.18. And this is how he explains why he's including that annexure. So firstly, we need to debunk the false claim that this affidavit was just thrown in the course of preparing the record. It was not part of the case before this court, the High Court in this matter. That claim is just false. So it is attached as KM11 to an affidavit filed by King Misuzulu in response to Prince Simakade's application. If you just have regard to 1753, the applicant there is Prince Simakade. And KM11 is referenced at page 1761, paragraph 6.18. He says, and he's explaining why am I attaching Prince Buthelezi's affidavit. He says, on the 4th of July 2022, Mbonisi yet again launched an urgent application under case 355-99-22 in this division of the Honorable Court. My present attorneys had hitherto been unaware of the existence of this application, as it had erroneously been filed under the above case number, rather than this case number, the present application. And the present application is Prince Simakade's application. And then he says, as an interlocutory application in the present application, it should have been filed under the same case number on case lines. And then he says, these are then the affidavits that should have been there. I refer particularly to the affidavits of Prince Mbonisi, the affidavit of Prince Buthelezi, annexed as KM9, KM10, and KM11. So it's this case where this was attached, this case we are dealing with. And there is a full explanation about why it was attached. So it's just factually inaccurate to claim that this was drawn in from elsewhere and then inserted mischievously in this case when the record was prepared. And so it's completely admissible, totally admissible, signed by Prince Buthelezi, which is KM11. You'll find that at volume 10, 1895. So when I said in these proceedings, the interim relief proceedings, this affidavit was filed, that was correct. The second problem is that Mr. Dodson says the meeting of the 5th of May, this is all of his curative thing. The meeting of the 5th of May was not to identify a king, but to nominate one. The problem is that is also contradicted by the record. If you go to volume 14, at page 2677, at paragraph 8, you will find their own notice of motion saying they want a declarator that the decision of the 5th of May identified Prince Magadi, correctly identified Prince Magadi. That's the relief they sought in their notice of motion. So, and if you look at paragraph 28 of the heads of argument that they filed in this court, 28 in the heads of argument they filed in this court, they say that Prince Magadi was correctly identified in the meeting of the 5th of May. Now, in oral argument, it's no longer identification, it is nomination. Who's fooling who? Now, so the point is that nothing is cured by this so-called curative exercise. Then the last point on this is they did bring an application to strike out all of the affidavits that they didn't like. They tried to strike out. They failed in the strikeout because these affidavits were not struck out. Affidavit of Mr. Mdlecha, affidavit of Mr. Maphala. They tried to strike them out, they failed. Then they applied for leave to appeal, and they got no leave on that issue. Mr. Dodson says something very odd. He says that no, the order said something as prayed for. Now, the order in the leave to appeal is at volume 25, page 4871. It's very clear. Leave to appeal and the leave to cross appeal as applied for by the respective parties against the orders of this court. Against the orders of this court, which is the part he did not read. What are the orders of this court?
Well, that's a question that I put to him, that you appeal against the order. Yeah. There must be an order. And then the response was that, well, there was no order here.
Well, but this is the point, Justice Sund. This is a very excellent question, if I might comment. Their remedy was then to apply for leave in this court. They could have applied for leave in this court in relation to the strikeout application, which they did not do. Mr. Dodson is the one to complain about an ambush. We are the ones who have been ambushed. And you know why, Justice Sund? Even in their heads of argument, they don't advance an argument in support of the strikeout. It all emanates in this so-called curative exercise, as if they have something to correct from us. I mean, why should we be corrected by them? So, on those three grounds, this curative argument must just be ignored. It's taking us nowhere. We then deal with the merits. What this case boils down to is custom. Let's be clear on that. This case is about custom. Prince Simagaje's heads of argument at paragraph 7 deny that the case is about custom. They say that we've incorrectly framed the case as a case about custom. But what we've then heard thereafter is a total desecration of custom, of Zulu custom. Let me explain, just on 2 points. We hear that there is no great wife. Everyone is equal in the Zulu household. We hear that there is no actual custom of succession.
I think that's Mr. Musuku's argument.
Yes, precisely the point.
Oh, no, you said Simakadi. I don't think it's his argument. He goes for custom.
No, I perfectly understand. It's Prince Mbonisa's argument. The problem with Prince Simakadi is that he denies that the case is about custom. That is a problem. And Prince Mbonisi, in paragraph 7 of their heads of argument, they deny that the case is about custom. They in fact say we're backing up the wrong tree. And Prince Mbonisi builds on it by actually denying the existence of custom on these two critical questions. One, there is no great house in the Zulu kingdom. Two, there is no set rules of succession. What that boils down to, I can sum it up in 2 lines. Custom is pretty much anything that happens. And even if nothing happened, that too would still be custom. Now, that mindset to custom, ironically, is a European approach to custom. That Africans are people without culture, people without custom. Because when you deny these 2 elements, which are the foundation of the Zulu kingdom, what are you left with? You are left with decisions made on the hoof, on the fly. Because the people meeting there as a royal family can pick up anyone. And that's why, Justice Nichols, I know you said this tongue in cheek, but you were correct when you said, can they choose me? Because it's the logical consequence of denying these 2 fundamental tenets. It's the treatment of Africans as people without culture. And the problem why they have to do this is this kind of convenience in argumentation. And I want to show this convenience now. Let's start with Prince Magade to show the convenience in argumentation. The letter of the 11th of May. It has been spoken about in several iterations. Let me focus only on volume 2825. Second paragraph. Ngiyezwa Mageba ukuba igama lami seliyathinteka ekubeni mina Simakade Jackson Zulu ngifuna isikhundla sobukhosi. I hear Mageba that my name has been mentioned, that I, Simakade Jackson Zulu, want to be the king. Ngijabulile uma ngibona umntwana kumabona kude ezisholo ngokwakhe ukuthi angikaze ngisho nakuye ukuthi ngiyafusa lesi sikhundla. Nami ngiyakufakazela lokho. I was very pleased when I saw you on television saying that I have never asked for this position. I also want to confirm that. Skip 2 paragraphs. Mangicacise ukuthi ubabekazi wami umntwana wakwaNdlovu. I also want to say my aunt from the Ndlovu clan. Benaye umntwana waseKwezi and the prince from the Kwezi clan. Bake basiqwashisa sizingane zenkosi. They warned us as the children of the king. Ukuthi uma isilo noma indlinkulu iphakamisa igama lomunye wethu, kufanele avume loyo oyobe ekhonjiwe. That if any of us is nominated or identified, we should agree. And here is the crucial line. Ngakho ke nami ukuba ngangiphakanyisiwe. It's past tense. If I had been mentioned, past tense, if I had been mentioned, ngangiphakanyisiwe, not ngizokuphakanyiswa. Ngangiyosamukela leso siphakamiso. I would have accepted that nomination, past tense. Futhi babe sixwayisile ukuba uma kuphakanyiswa omunye wethu asibo wamukela futhi simeseke loyo oyobe ekhonjiwe. They also warned us or counseled us or advised us that if one of us were to be nominated, we must support and stand behind them. That is what he said. He was talking about the past tense. This is a distortion, this argument you are hearing today, that this was about the future. It was about the past. If my name had been mentioned, I would have accepted. But I have told you that I have no such inclinations. But we know in the past that on the 7th of May, another name, that of King Misuzulu, had been mentioned. That's the context of the letter. He denies that his name had been mentioned on the 5th. But the judges, I think, were correctly skeptical of that version. How is it possible that a position of kingship can just be given to you without anyone speaking to you before. It's just so improbable that it has to be rejected without more. So the letter of the 11, that's the first thing. The second thing that is crucial about this letter, it destroys this notion of ukufakwa. And here is why, Justice Zondi. By the 11th of May 2021, Prince Simakade knew about this alleged ukufakwa. He also knew that the consequence of it is that he will become the king. Why is he talking about being nominated? Why is he not simply saying, ladies and gentlemen, the moment has now arrived. I am the new king of the Zulu. So his letter of the 11th of May is completely destructive of any notion of kingship succession via the custom of ukufakwa. Totally destructive of it. And it is never explained why this claim was made. This is why we get for the first time, this reference to ukufakwa in the letter from Princess Thembi on the 3rd of June. But the actual owner of this custom never makes a claim based on it. Because he knew at that point that there is nothing like this. And that is why Prince Mbonisi, in his affidavit, actually expressly denies that Prince Simakade is entitled to kingship via ukufakwa. Explicitly denies it, says this is wrong, it's untrue. So, his own co-applicant says the man is lying. Not lying in that sense, but has no claim to the kingship. Every other affidavit you have seen in this case disputes from the experts, from Prince Zulu, from Mr. Prince Buthelezi, from Mr. Mdleje, Mr. Mapalala. Everyone you have heard disputes this idea of ukufakwa as a method to succession. And you will see Prince Mbonisi's denial at volume 18, page 3526. Paragraph 113, 3526 at volume 18. This is what he says. It is therefore not correct for Prince Simakade to lay claim to the throne through the culture of ukufakwa esiswini, when it was not appropriate for him. He is not the sole heir to the throne as the eldest male child of the late King kaZwelithini's. And I can say without fear of contradiction that Prince Simakade is mistaken and misconceives our culture and tradition. It couldn't be stronger. Then the third point is to go back to the letter of the 3rd of June. What we heard from Mr. Dodson is that the letter is long. Many things can be long. But we must look for where it fits Section 84A. Where does it talk about why the succession is inconsistent with custom? It only deals with that once at page 2509. Paragraph 10.17. It says, having regard to the foregoing, it follows that at no stage was Prince Misuzulu identified and or nominated and accepted by the royal family for the purposes of being recognized and appointed as the one to ascend to the throne for the following reasons. So he gives reasons. That's the only part where he says Prince Misuzulu is not entitled to be identified. These are the two reasons. One is the meeting of the 7th of May, which she claims did not amount to a meeting of the royal family. B, the meeting of the 14th of May, which she claims was called under false pretenses. Those are the only two reasons. There is nowhere here where the specific issue is being dealt with, where it is set out This is the custom we follow. This is how the custom was not followed. This is why you end up with this contradiction. Because the fundamental argument raised by Prince Mbonisi is about the composition of the Zulu royal family. And the argument raised by Prince Simagade is about Ukufawa, which, as I have demonstrated, the 11th of May, which exists the 3rd of May, totally destroys the idea. It shows this to be a late blooming theory. The problem is this: once you have tied yourself to this version, that this is why you are saying this king was not identified in accordance to custom, is because of these two meetings. You then have to show where in the custom does it require the royal family to be the one that identifies the king. Where in the custom? The custom is explained by Prince Buthelezi. In the affidavit, by the way, they don't want. And that is the affidavit at...
the unsigned affidavit?
No, the signed one. The signed one. And that is volume 9. And I have said to the court...
Volume 9 page?
Volume 9, yes, page... sorry, that's the wrong one. Sorry, it's volume 10, actually.
Take your time.
Yes, volume 10. So that's the one they don't want. And I've said to the court, for my purposes, you can disregard the unsigned affidavit because we are relying on affidavit properly commissioned, filed, given to them. So the affidavit at volume 10 at page 1895. Prince Buthelezi explains the position of the royal family in the succession. If you go to page 1932 to 1933, you look at 1933, he first explains the custom. And if the Zulu people are to be taken seriously as the preeminent nation in this country, they do have customs. And these are customs that predate all of us. The entire constitutional project was to lift these customs to be on par with the common law. This idea that custom is anything that happens is totally foreign to customary law. If you actually asked practitioners of the custom, they would be astonished at what has been going on today. Prince Buthelezi says at paragraph 107, page 1933, he's explaining the role of the royal family. He says, perforce, King Misuzulu ascension to the throne was a foregone conclusion. Why? Because it's regulated by rules of custom. The same as the ascension to the British throne. It's regulated by pre-existing rules, not by things that are made up on the fly. This is to say, the royal family had no wiggle room. The royal family had no right to ignore custom, to see matters differently, and to depart from settled customary law position. To do so would have been offensive and contrary to the provisions of Section 17 of the KZN Act. The royal family had little or no choice but to identify King Misuzulu in the circumstances. This is so because Section 8 of the KZN Act expressly provides that the royal family must take its decision and perform the identification in accordance with the customary law, unless the disqualified criteria in Section 9 and 16 of the Act is applicable. When yesterday we began by saying what this case is about is custom, you have to put custom front and center of the idea. Custom is binding on the royal family. Custom is also binding on the courts because Section 211 subsection 3 says where it is applicable, it must be applied. And all of the judgments we've referred to say the mistake of the South African courts is to always view customary disputes through the prism of the common law. The only circumstance in which custom is displaced is where there is a statute specifically dealing with customary law, which may develop customary law, may abolish customary law, may change customary law. But otherwise, customary law is a distinct body of law that operates alongside the common law. If this court subjected customary law to all of these things we've been hearing today, this would be the end of customary law in this country. So when Prince Buthelezi says, we, even as a royal family, are bound by custom, there is no real dispute about that. No real dispute about that. In fact, what illustrates the point is the conflict in version between Prince Mbonisi and Prince Magadi. Because Prince Magadi needs the custom in order to insert himself into the womb. Without the custom, he is unable to insert himself into the womb. He needs the great wife in order to ascend to the throne. So the role of the royal family is totally explained. It has no power to override custom. We come back to this letter. This letter never says that this is the custom of the Zulu, that the royal family does whatever it wants. And Prince Simagade was trying to read customary law as if it was a political election. I'm waiting for my chance to be elected. But no, there are rules of succession decided by generation after generation. All our job now is to discover them and apply them. That then takes me to the fourth issue, which is the royal family issue. I've already addressed what Prince Buthelezi says about the royal family. But we also need to debunk this idea of the case of Mpepu. That case has nothing to do with what we are dealing with here. That case says, when you define royal family under Section 1 of this Act, of the Poison Act, royal family is the ruling family plus other members of the family. So this idea that it excludes other members of the family is actually not part of the Act. The problem in Mpepu was that there were strangers, and you see this at paragraph of that Mpepu judgment. Paragraph, I think it's 34. Yes, that's where what they, oh yes, it's paragraph 38, sorry, not paragraph 34, 38. It says, the appellant questioned the presence of traditional leaders who were not members of the 8th respondent in the meeting. And then it explains what the definition of the royal family is, the core customary institution, including other relatives. And then it says, there were members of the Royal Council present in the meeting. That's the meeting of the identification. The Royal Council is an administrative structure established in terms of the Framework Act, and some of its members would also be members of the royal family. The persons who serve as both the royal family and the Royal Council are entitled to attend and participate in royal family meetings. However, the members of the Royal Council who were not related to the Mpepu Ramabulana royal family were not entitled to attend the meeting of the 14th of August 2010. That's really what was being said, that you've brought in strangers to Indaba yaKwaZulu. That's the problem. Brought in strangers. But you have the right people here, and that's repeatedly explained by Prince Buthelezi's affidavit. That then takes me to the fifth issue, which is the res judicata issue. Ms. Muvangwa has, in an excellent address, explained to the court that the doctrine can be relaxed. The source of that is S versus Mulawudzi, the judgment of the Constitutional Court, S versus Mulawudzi, specifically at paragraph 45, where it says that you should not be too rigid on the res judicata. If you can see there's a manifest injustice, you should relax it. But they explain that there is another constitutional value, which is the value of finality, which is important for the rule of law. Zuma versus the Judicial Services, versus the State Capture Commission, which is the finality in litigation. That's also a constitutional principle. The two must always be balanced. And then they say the exception to the exceptio rei judicata is where there is no alternative remedy. And the problem with Mulawudzi is that he was in prison. And there had been a judgment that already said that his case was dismissed, but he was in prison. And the question was whether or not to allow a man to stay in prison, despite the possibility of a defense that had not been considered before. That was the manifest injustice they were dealing with. And then they said there is no other alternative remedy. We have to rescind. We have to relax the excepio judicata, which is what they did. Now here, what are we dealing with? We are not dealing with someone in prison. We're just dealing with people who just want to be killed. Number two, we are dealing with an instance in which there was more than adequate alternative remedy. The most important remedy is an appeal. The res judicata principle is not violated, the access to justice principle is not violated simply because an appeal has been refused. You've gone there, you've tried, it's been refused. If you don't like it, well, do a rescission. We know some people who've done it. And if you fail, that's it. At a certain point in time, it's a constitutional principle that the doors of the court must be closed. What we cannot tolerate is permanent litigation. That's the first answer to res judicata about the plea for relaxation. The second answer to it is this notion that from paragraph 85, take a red pen, scratch everything. We need to distinguish two things here on this part. The one is, what do you say to the president? The president has got a judgment of a court. He needs to decide whether I give effect to this judgment by recognizing, because it says there is no section 84A valid claim. If you gave a judgment that said even the president is entitled to take a red pen through a judgment of the court, then let's close the judiciary. Then you have another scenario in which you are asking yourself, what about another judge? The same applies to another judge. What had happened, in fact, Ms. Muvangwa explained this properly. The one point just needs to be emphasized. If you go to that volume 1 and you look at where this paragraph 85 appears, what that paragraph 85 is about, sorry, paragraph 84, because according to Mr. Dodson, we must take a red pen from 85 and then up to 102. But the paragraph before then, it says, according to the second, sixth, that's at page 155, volume 1, paragraph 84 at the bottom of the page. According to the second, sixth, and 12th respondents, the applicant prince also does not have locus standi to bring an application to stay the identification, recognition, and coronation. Prince Mangosuthu Buthelezi states that as the Prince Minister of the Royal Nation, he is the only one who is authorized to convene meetings of the royal family to discuss matters pertaining to the royal house. Prince Buthelezi goes on to state that no one has ever convened such meetings except him. This issue should be decided on +1 evidence, and as a consequence, the version of Prince Buthelezi is accepted in this regard. Further, his application, the prince's application, is characterized by the non-joinder of the members of the late Isilo's family, that is, his queens and their respective children. Not even the applicant queen and the applicant princesses, whose applications the applicant prince claims to be supporting, are joined. In the applicant queen's application, where he has been cited as the seventh respondent, the applicant prince did not take any interest in the matter, and thereby effectively elected to abide the decision of the court. The applicant prince furthermore does not state whom he represents. The applicant prince has approached this court on misinformation and incorrect facts. He eventually admitted that there is no official coronation of Prince Misuzulu utilizing public funds underway. Consequently, the applicant has not made out a case for the relief sought in the notice of motion. That's the coronation relief. But it's on joinder and locus standi. Now, on spillhouse, the Constitutional Court says where you are dealing with a constitutional matter, you have to answer all of the questions because the case may go up on appeal. He then answers the rest of the merits of the case, including, most determinatively, the validity of the meeting of the 14th of May, including the content of the custom, including the legitimacy of King Misuzulu as a king of the future king of the Zulus, decides all of them. Now, this idea that you can scratch that is just illogical because you can't do it for rule of law reasons, but you also can't do it because those findings that came thereafter were necessary as part and parcel of the discipline recommended by Spillhouse of the Constitutional Court. There is a third problem with this, which is from Tasima, I referred to Tasima in my opening address, but perhaps I should have gone further than that, particularly from paragraph 179 up to paragraph 199. And the Tasima judgment makes this point. Even if a judgment is invalid, say it has been issued by a judge without jurisdiction, it's going to usually be regarded as a nullity. He says, even if a judgment is a nullity, until it has been set aside, it is binding. So whatever you think, whether it is a nullity or whether or not it was given outside of the strict parameters of judicial decision making, the fact is it's the factual existence that determines whether it's binding or not. So vis-a-vis President Ramaphosa, it was binding. But unless it could be dealt with differently by Judge Davis, it was also binding on him. In fact, in paragraph 36, he found that it was binding. And then on the merits, the last point that has not been addressed, one of the grounds of attack that we have put forward is that there is an internally contradictory judgment between paragraph 36 and paragraph 66. I did not hear anyone address that. And I said on that basis alone, the judgment simply cannot stand. Because it could not find on the one hand that it is bound by the judgment of Judge Madondo, and on the other hand, seek to reopen the very issues that were closed by Judge Madondo. I had no answer to that. Then finally, I just want to summarize the contradictions that are characteristic of this kind of litigation, which is litigation driven by convenience. Number one, Prince Mbonisi says there is no custom, and it all depends on the views of the royal family. Prince Simagade says there is a custom. That's the first contradiction. Number two, Prince Mbonisi says there is no great wife. But for Prince Simagade's argument to hold, it depends on the great wife. Number three, Prince Mbonisi says that there was no Ukufagwa. I've just referred the court to the passage. In fact, Ukufagwa is irrelevant. Prince Simagade's entire case depends on Ukufagwa. Number four, Prince Mbonisi says that certain rituals had to be performed before identification. And yet, there was identification on the 5th of May in the presence of Prince Mbonisi without any of these rituals having taken place at all. Now, these four contradictions are at the heart of it. They just show why the High Court simply could not take seriously what these applicants had brought before it. And if you compare to the respondents, we put reams and reams of relevant material to show what the content of the custom is, because that is really the only decisive issue here. And contrary to that, there's just no other evidence. You are now being dragged into this under the guise that, oh, it must still be determined. It cannot be redetermined because it has already been decided by custom. This idea that there's still something else to be discovered is completely refuted by the overwhelming evidence before this court. So we would therefore submit that the correct order is to uphold the appeal, set aside the judgment, dismiss the application. We persist with our cost order. I hear what Mr. Dodson is saying, that they are still going to work together, etc. That's something they must solve after they have received a cost order. If that king decides not to execute, that is up to him. But as a private party, he is entitled to his cost order. There is no biowatch protection as far as the individual litigants are concerned. Mr. Dodson is talking about another case. He says he found another case where there was no cost order. There is no law that says in litigation between private parties there should be no cost order. So the king respectfully instructs us to ask for a cost order if we are successful in the appeal. I thank you, Justice Sonke.
Okay.
Thank you.
Just trying to clarify whether my colleague has forfeited his reply opportunity and it's my turn.
Sorry?
Deputy President, I'm just trying to clarify whether my colleague has forfeited his reply opportunity because of the nature of his initial address, or whether it's my turn to stand up.
But was the arrangement that you'll deal with the cross appeal in your main submission? But that was the arrangement.
Yeah. Done.
Yes.
The arrangement was that we were 2 hours each.
Yeah, but no. You remember there was a letter, and then I said that the 2 hours is inclusive of everything. But I'm going to give each of you 5 minutes. It should be 5 minutes, nothing more.
President, I'm indebted to...
Yes. It's 25 to...
Sorry.
Now, you've got until 22. Yes. Yes, Mr. Moran. Yes, you are excused because you have got 2 juniors here. Thank you, Mr. Moran.
President, I do want to respond to just an aspect which was complete mischaracterization of Prince Monice's submissions in respect of the existence of culture. There was no suggestion, and it's completely erroneous suggestion to say that the Prince Monice's application should be seen as a Eurocentric articulation of Zulu culture. It's complete. There is no evidence here is presented of what Eurocentric culture is. It's a completely erroneous and misinterpretation of what the issues are. It was made very clear that what the royal family, represented by Prince Mbonisi, would like to have is a right bestowed to them in culture and custom to identify an heir. If one reads the affidavit or the affidavits filed by Prince Mbonisi on behalf of the royal family, a suggestion that the sum total of his argument is that there is no culture, or culture is whatever he makes as you go along, would be any responsible reading of the affidavits and the submissions that are made by Prince Mbonisi. So we would say that it would be astonishing for this court to understand the submissions, both made orally and written in heads of arguments and in affidavits, to accept the proposition that's being made in reply or in answer by my learned friend for King Misuzulu, that we prevaricate. We say there is no culture, and that would be legal. This is the highest right now in the royal family. It would be wrong to suggest that what they've come to do in court is to say that there is no culture of the basis on which their complaint should be resolved. They have made out a commendable case in their written papers. We hope that we have managed to deal with the issues that you were asking us in relation to what exactly our case is.
Yes.
And it is nothing far from suggesting that we're belittling culture because we say that there is no great wife and that there is no great wife in the Zulu royal family. Just on that point, there has not been a single.
Well, he might have articulated culture as he understands it. The question is whether his articulation of the culture is correct.
Yes, that's correct. But one must accept him being a senior member of the royal family, that he knows the culture.
Yes.
And what he says should not really be subjected to ridicule. Even if he's wrong, the point of the matter, he is not making a Eurocentric proposition. in respect of the issue of the great wife. One thing you must understand is that there is no suggestion that any of the Zulu kings were children of a great wife. They must just tell us, refer to us, the late king was not a child of a great wife. His father was not a child of a great wife. So where is this great wife theory coming from? So we say it's important that even as we discuss culture, we do it fairly, and even experts will differ on what culture is. That's not something that can be derided as demonstrative of a mindset that doesn't appreciate culture. But there is also
5 minutes is up, Mr. Misuzulu.
Can I just make one last point, President? I know I was the one person that you asked many questions. I was hoping you'd have grace with
but no, we have given you more than allowed.
You were quite rigorous with me yesterday.
You are junior to argue.
But I do want to say, President, if you allow me to make the last submission. If one looks at volume 18, from pages 33481, and read just these affidavits by Prince Mbonisi, and bearing in mind that the reliance on Prince Buthelezi has to be tempered by the fact that in the review application of Prince Mbonisi, there is no affidavit from Prince Buthelezi. What has happened is that affidavits from other courts have been brought in, and I accept that some of them were brought by us. But the point of the matter is that in the review application where it mattered, what we are told is that Prince Buthelezi had a full affidavit before him. He refused to sign the affidavit. What does it say about even the things he says in other affidavits that are now being incorporated into the arguments that are being made now?
Well, yeah, okay. But I think that point has been exhausted, Mr. Misuzulu.
I'm happy if you just the last thing. The order that we seek, as Mr. Smelane said, is an order upholding the Judge Accord on Order 1. On Order 2, dismissing the application and upholding the review application of Prince Mbonisi. The orders are in the notice of motion, and that would be in the volume 1 of the record.
So the relief that is sought is in accordance with the relief sought in the notice of motion?
Yes.
Okay, thank you.
I was hoping you'd ask me another question, so I have time.
No.
I thank you for the question.
I don't have energy now. Okay, Mr. Dodson, 5 minutes also.
As the court pleases.
That's it.
As the court pleases. Good. Just briefly, my learned friend, Ms. Muvangwa, for the President, sought to point out that Prince Makade ought to have sought to rescind or appeal the order of Justice Madondo. Well, with respect, that would have been even more foolish than joining the application. There was absolutely no reason to overturn the judgment. The order is correct, and Deputy President, as you pointed out, you appeal against the order. The order is correct, there was no reason. The case, of course, it should have been dismissed. But for the reasons that it was moot and that there was non-joinder. In relation to the reference to the hibiscus case, my learned friend Ms. Muvangwa in fact referred to what was the submission of one of the parties. If one continues in paragraph 16, what one will find is the court's decision. And the final sentence reads, at best for the municipality, the statement side were in fact going to express a view about what the court rule means, which as I've shown is not the case. They are mere contradict and not binding. The municipality's reliance on the passages therefore misplaced. So it seems to us, we haven't studied the judgment carefully, that it supports us rather than them, as it were. There has been, moving on to my learned friend for Prince Misuzulu, there was debate around this affidavit that was referred to, and I think my learned friend with respect has misunderstood what our objection is. We're not suggesting that documents were sneaked into the record. Our complaint is the one that I explained and gave references for, and that is that affidavits were filed after pleadings had closed without the permission of the High Court. And that's exactly what Prince Misuzulu's supplementary replying affidavit did. It was offending what the court had ordered should be the arrangements. And this affidavit was attached to it, and it's subject to the strikeout application. So it is inadmissible. Our learned friend should not have referred to it again. And there's a further basis upon which he's not entitled to do so, is that it remains an affidavit from a different court case. It can't simply be deposited into this case. Then, as far as the issue of whether or not we applied for leave to appeal and whether the judgment dealt with it, if I can refer this court to the judgment of the Constitutional Court in Tembani and others versus, it's President of the Republic of South Africa and another versus Tembani and others. And I'll just give the South African Law Reports reference. It's 2025-2, SA 371, CC, and the relevant paragraph is paragraph 75, which reads, by making no formal order on the condonation application, the High Court in substance made a decision in favour of the plaintiffs on the primary contention, namely that they did not need condonation, and a decision adverse to the defendants, namely by rejecting their prayer for the dismissal of the condonation application. So a silence on that aspect can, if the court is silent on giving something that you had asked for, one is entitled to appeal it. And in fact, the Tembani judgment overturns an SCA judgment that adopted the attitude that if it's not expressly in the order, then you can't appeal it. This effectively reverses that. So the absence from the order of the High Court in relation to the strikeout applications is something on the basis of Tembani paragraph 75 that we are entitled to appeal against, and we've taken the court through the chain, through the application for leave to appeal and into the notice of appeal. The final reference I'd just like to give and point I'd like to make is in relation to the reference to Tasima and the suggestion that one has to overturn a judgment before it can in truth be recognized as a nullity. There's an exception in the case of res judicata, and it's referred to in paragraphs 191 and 192 of Tasima. I won't take up the court's time with reading it, but the point is that when you are raising a plea of res judicata, it is not necessary, on a proper interpretation of those paragraphs, to go to court and get the order set aside. And that's the problem we have. There is no reason for us to go and get His Lordship, Mr. Justice Madondo's order overturned. Those are the submissions in reply. Thank you for indulging me.
Okay, let's see what time. All right. The court wishes to thank everyone who was involved in this case, counsel, for the manner in which they have argued the matter, and the court will reserve the judgment. So those who are, I know that there's a lot of people who have attended to these proceedings and are from far away. So we say to them, have a safe trip going back home. The court adjourns.